Not this appeal by the state, my lord, against the judgment and order, judgment of the learned single bench, my lord, whereby the single bench has directed the state to pay a compensation of 50 lakhs as ex gratia compensation to the writ petitioners. My lord, here the issue is only on the interpretation of the scheme, my lord. And the only point to be decided is while the difference between while performing duties or just while being on duty. That is only the difference, my lord. My lord will kindly, I'll take your lordship first, my lord. At page 257, my lord.
257.
Yes, my lord. I'll read the introduction, my lord. On the occasion of the 70th Independence Day celebration, the Honorable Chief Minister had announced that the state government would frame a policy for award of ex gratia payment of rupees 50 lakhs only to all the state police personnel, irrespective of rank, who fighting any terrorist criminals.
257.
275.
Yeah.
275, my lord. Introduction, my lord. On the occasion of the
objective, the policy.
Yes, my lord. Objectives is A, to provide ex gratia grant to all those state police personnel, which Arunachal Pradesh Police, Arunachal Armed Police Battalion, and IRBN personnel, irrespective of rank, who are killed or permanently disabled or grievously seriously injured while fighting terrorist militants, criminals, underground elements, or while performing.
While performing law and order duties.
Yes, or while performing law and order duties or disaster management duties in the state of Arunachal Pradesh, my lord. My lord, here the writ petitioner's husband was IRBN personnel, admittedly. And quantum.
He was performing his duty in the gate, check gate, during COVID.
No, my lord, here.
COVID duty is also include the disaster management.
Yes,
duties.
So, but he.
Where's the FIR? There's an FIR.
Yes, my lord. He was returning from duty at page 221, my lord. FIR. To the officer, Rowing Police Station, so and so. With due respect, I am to inform your good self that today at around 18:30 hours, our constable Amos Regan, so and so, who was on round clock duty at Santipur check gate in view of pandemic of COVID-19 and was along with our section of force.
Where you were reading?
221.
231.
221.
220, yes.
With due respect, I am to inform your good self that today at around 18:30 hours, our constable Amos Regan, so and so, who was on round-the-clock duty at Santipur check gate in view of pandemic of COVID-19 and was along with our section of force, so and so, was entrusted with the responsibility of patrolling along the porous Assam-Arunachal boundary and died after a motorcycle so-and-so collided with a barricade at Forest Check Gate. The said personnel Amos Regan was on duty at the time of accident and had gone to cross-check the information that some miscreants from Assam were trying to enter through the Dharan village into Arunachal Pradesh. While on his return, he met with the accident and was immediately rushed to hospital, Rowing, where he was declared brought dead. This is for so-and-so. He was after performing duty.
Not after performing. This you read this was on round-the-clock duty.
Yes, my lord.
And while on his return, he met with an accident, was immediately restored. Yes. Round the clock.
That's why, my lord, while on return, not while performing duty, but while on return from duty, there is a difference, my lord. Simpliciter being on duty.
See, first of all, he was engaged on round the clock. What do you
Yes.
mean round the clock?
Round the clock duty,
It cannot
but
be 23 hours.
yes, my lord. That he was on duty. That is not disputed.
Not duty, not only duty, round the clock duty.
Yes, he
So-
was on duty. That is not disputed. We interpret that he was on duty.
Round
But-
the clock duty and
Yes, round the clock duty, but he died not while performing duty, my lord. There should have been a direct
Sir,
connection.
if it is round the clock duty,
Yes, my lord.
whether going there, here, if he met in an accident, unless in a after the duty hours,
On his return, he met with the accident, my lord.
what do you mean by around it?
No, my lord, even then, my lord, it is the scheme envisages only while performing duty. If you are going for performing that duty also, that will not. If you meet with an accident
From where,
while going for
Where it
performing
is-
a law and order duty.
where it is defined?
Yes, my lord. Here in the scheme itself, that's why scheme itself, if I am entrusted to go and perform the law and order duty, now I start from here and I'm entrusted to if I meet with an accident before performing, that I will not be covered, my lord.
So as that
The scheme itself, my lord,
when his duty ends before
my lord, the scheme itself says
no, when
while
his
performing
duty,
duty.
he was entrusted, engaged in the round the clock duty.
round the clock duty.
It says while on return, while on his return,
Yes, my lord.
when his duty ends.
The scheme emphasizes only while
That's what I'm
performing.
saying. You show us that he has left the duty, he has completed
Yes,
his duty.
my lord, the
When the accident was met, when he met with an accident, he was not on duty.
my lord, accident was met while he was returning after the checking. He was returning. He collided with his motorcycle collided with a
Where
barricade.
do we say that after the duty?
No, my lord. His accident was occurred not while performing the duty. What he was on duty. That is not disputed.
See, this was at 8:30.
Yes,
6:30, I mean 4:30. No, 6:30.
6:30.
18:30.
6:30.
And he was engaged on round the clock duty. What do you mean by round the clock?
Round the clock, but if it is on a disaster management duty, if he is while performing that duty in a disaster management can be like if someone has drowned.
Suppose
Yes, ma'am.
at 1 o'clock we rise for a lunch.
Yes.
While sitting in a chamber, will it not be considered as a duty or is it a...
Yes, that will be considered as a duty.
See, therefore, this he has been engaged in the round the clock duty.
Yes,
On
my lord.
round the clock duty.
Yes, my lord. Here is the case when there
You
is
tell us what is
Yes.
round the clock.
round the
I mean-
clock, my lord. That's why we are saying that this scheme is when it will be applicable when any this
Please.
person is while performing, not just being on duty will not be sufficient, but will be applicable only when he is performing that duty. A law and order duty, well, if there is some law and order duty and he gets killed in that or gets seriously injured while performing, it's not that if you are deployed for law and order duty, but while going for law and order duty, you meet with an accident or there happens something, you will be covered immediately. It's not that. Or after performing the law and order duty, if you are coming back, if something happens, that will not be covered. Therefore, it specifically says.
Yes.
My lord, I'll again trouble my lord at page 275, 276, my lord.
Yes, while performing law and order duties or disaster management duties in the state of
Yes, my
Arunachal
lord.
Pradesh.
Here the word is while performing.
Hmm.
It does not, it will not simply cover while just being on duty. Everyone will be on duty.
That will be too harsh. That
My
will
lord,
defeat
that's
your
this
own,
is a
defeat your
special
own policy.
ex gratia compensation. Amount is big. Every police personnel are always on law and order duty, my lord. In that event, it will be applicable to any sort of duties, my lord.
It's a kind of welfare.
Yes, my
it's a
lord.
policy.
Welfare policy, and that's why it has to be given only when a person dies or seriously injured while
performing duty.
Yes, ma'am. Otherwise, every
performing duty, had it been a normal period, say 9 to 4, if he dies in the night after 5, one could understand.
my lord,
He was engaged in a round-the-clock duty. What do you mean by that? Round the clock.
round the clock
We're
duty.
asking.
Yes, round the clock duty. He was engaged in a duty. He was on
Round the
duty.
clock.
Yes, he was on duty. Round the clock duty.
For how many hours? Round the clock means
Round
what?
the clock, he was
What we have
so long as
understood, round the clock is 24 hours.
24 hours. Yes, my lord. He can be on 24 hours duty, but my lord, the accident or his cause of death should be while performing the duty. His cause of death, his cause of serious injury or injuries should be directly connected to while performing the duties. Any person can be on duty, but this scheme will be if while performing, specifically performing that duty.
No, that's why clearly said who are killed, permanently disabled, or seriously injured while fighting terrorist,
Yes,
criminal under elements,
Yes.
or
Yes,
while
or
performing law and order duties or disaster management duties.
while performing. Yes. Here, my lord will kindly see who are killed, permanently disabled, or seriously injured while fighting. It's not when you are going for fighting. If it happens that you are deployed to fight, but on the way you meet with an accident, you cannot be covered here.
Understand. But this was when, if he was engaged round the clock.
Yes.
And during the COVID, well, he was going here or not. He was on duty. He was performing his duty.
Yes. He is on duty. Not every here.
It was like as good as in a battleground.
My lord, here
he was engaged round the clock.
If I can give an example, my lord, disaster management when there are landslide, this floods and all, it is a person who goes if they are deployed of forces are deployed. If they go for that rescue operation,
yes,
they will be entitled only performing that. If you go from here, you start your journey while performing that disaster management, while diving and rescuing someone.
Will issue notice.
Yes, my lord. In that event, my lord.
My senior is in online, but due to some technical problem, cannot take place. So matter may be fixed on 28.
My lord, notice may be issued. This may be ultimately heard, my lord. In the meantime, since there is a contempt pending, my lord, this may be heard, my lord.
Just because there is a contempt.
No, my lord,
proceedure,
here prima facie
Therefore,
case.
you have filed the appeal.
No, no, my lord.
Then
We have filed it
why are
earlier.
you mentioning the contempt
My lord,
proceedings?
they are time and again taking time, my lord. And then they are
Lordship,
pressing
they are
the contempt, but
online.
they are taking time in this writ appeal.
Are you interested in your ex gratia amount or to furnish the officer?
Lordship, I can't say that because senior is not here. Kindly the matter may pass over then.
We have fixed it on your presence, in your presence.
Lordship, my senior is in online,
On
but
your
due to some
submission.
technical problem,
Hmm?
my senior is already in online, but due to some technical problem, not appearing.
What can you do?
Pass over for some, after some time.
Sometimes.
No problem is then Monday.
My lord, they are seeking
they
for
will, because,
pass over,
if no,
pass over for some time.
we cannot. We have the single bench also. Can your senior appear physically on Monday?
In video only, he cannot appear physical on
We
Monday.
see it's very difficult.
On 28 only he'll be coming. On
20
28,
Huh?
on 28 only he'll be coming here
We'll
physically.
have to wait for the lawyers to only his convenience or what?
Yes,
This matter has been fixed today
yes,
in
Lord.
your presence. We have requested your senior to be present.
Please. Okay, then for Monday, but
Hmm?
on Monday. It's for the Monday.
Although this matter heard Mr. N. Ratan medicine for the appellant. Although this writ appeal has been fixed in the in the consent of the learned counsel for the respondent from MS D. Rilu learned counsel appearing on behalf of Mr.
AK Prakash.
AK Prakash, learned counsel for the respondent. Submits that our senior Mr. Prakash has some personal difficulty again today, therefore pressed for listing of the matter on 23rd. 23rd,
23rd.
not 23rd. We'll make it 24th. 24th, Tuesday.
Thank you.
Considering the engaged counsel, Mr. AK Prakash, the learned counsel has some personal difficulty. Let this matter be listed again on 24th, on which date no further adjournment shall be granted. No further adjournment.
No.
Even if you seek also will not adjourn.
All right.
Yes, sir.
Please, your lordship. My lord, we are, I'll show the judgment, what is the error, but 2-3 things, the dates are important. My lord, this particular tender pertains to this revamping of the old electrification works in different districts. So there was a tender which is floated by Department of Power in respect of all the district. We are concerned about the Pasighat district. So tender, we participated, 7 bidders participated. Out of 7 bidders, 3 bidders qualified. And on 21st, 21/2/2024, my lord, my bid was rejected. saying that it was abnormally low on 21/2/2024. Now, there is a provision under the standard bidding document, 36.2 and 36.3. If any bidder's rate is abnormally low, then you have to give a chance to demonstrate that why it was low and below the justified rate. Now, this thing was not done it. It was not adhered to it. That is why a request was made by the chief engineer. In the meantime, we filed a reply. We filed a reply on 13/2/2024, stating that this is not low. This is within the justified rate. Now, on 14, the chief engineer has issued a letter to superintendent engineer saying that you have to give a chance to justify the rate under 36.2, 36.3. Accordingly, he has given a chance, and thereafter, on 26/4/2024, it was communicated saying that your low is rate, so we cannot accept. That's the my lord, the facts
By the tender committee.
by the tender committee.
Tender.
Yes, tender evaluation
evaluation
committee. Yes. Now, thereafter, what has happened? In the meantime, in between, from 26/4/2024, subsequently, there were a lot of complaints in respect of almost all the district by the bidders that the bid which is given by the bidders, it was abnormally low. It was not within justified rate in almost all the
In other
districts.
district also.
Yes,
In
all the
other
other
tenders.
district, other packages. So, by a memorandum of the government in the month of May, they decided to form a subcommittee. Special subcommittee was constituted by
all
the government.
district, For all
Yes,
tenders.
but I will tell your lordship, this package, Pasighat package, initially it was not included. But all the packages it was included because there were a lot of complaints. Now, there was a subcommittee which was constituted. Now, it is very interesting, the chairman, who is a chief engineer in electrical division, where all these letters are being issued, he was a chairman of the subcommittee. And the finance were there and the Department of Law was there. So now they have, this is somewhere in the month of May, my lord. So the subcommittee constituted and the issues, I will show it, they have the formulation of the issue was keeping in consonance with 36.2, 36.3. All market rate, everything was, they deputed person and they say this is the market rate. And ultimately their conclusion is that is within the justified rate. 16% above the justified rate, so far as the Pasighat is concerned. That is a conclusion. And respect of two other packages, they said it is below minus 3.84. So this is the report which 15/7/2024, ultimately the report was prepared and it was sent to the government. Now, on 21/11/2024, my lord, a representation was filed by the private respondent. He was a bidder. He filed a representation to the secretary, making that what is this? Why you are waiting? My particular bid has to be reevaluated. Now, this chief engineer, in pursuant to the secretary letter, wrote to the superintendent engineer, you reevaluate the price bid of the private respondent, who was a petitioner as a writ petitioner. So my lord, on 26/11/2024, his representation was taken into consideration and it was reevaluated. And on 3rd of January 2025, this particular was sent. They reevaluated and they said, yes, he should be considered. And accordingly, it was considered and it was sent to the government for approval. Now, in the meantime, on 12th of January 2025, which ultimately is intimated by an LOI, LOI was issued to us on 15th of January 2025. Now, 3rd of January 2025, report was furnished. Then on the basis of the report, this particular LOI was issued to us on 15th of January 2025. Now, they are aggrieved by that. They approached the learned single judge. Basically, their contention is of twofold. They said that there is a memorandum which is issued on 18/9/2023 by the government. So any justification, justified rate has to be in pursuance to the standard bidding document 36.2 and 36.3. That is not been adhered to it. This is the first ground which they have placed before the learned single judge. That's for the argument which was advanced. And that is not been adhered to it. Now, second ground, where is the question of formation of a subcommittee? This is not in consonance with the terms and conditions of the the NIT. This is the second ground which they have argued before the learned single judge. Now, affidavit has been filed by the government. A reply has been submitted. And they said in the affidavit, which is a part of the judgment also, and the government said that no, the terms, the memorandum which was issued, standard meeting document 36.2 and 36.3 has been taken into consideration by the subcommittee. And there was fairness and transparency was there while deciding by the subcommittee. And there was nothing wrong which has been done by the subcommittee. There is no deviation of the standard meeting document 36.2 and 36.3. So now, this is what it was projected by the government advocate, my lord, before the learned single judge. But the learned single judge, the finding, I will take to that finding. My lord, first your lordship will look into it. The page 156, my lord. Kindly see 156. I'll show the judgment. Kindly see 156 of the terms and conditions of the NIT. (106) is the NIT. Your lordship will kindly see 106 first. This is NIT at notice inviting tender. Kindly see the NIT, my lord. This is 17th of January 2024. And if your lordship kindly see name of the package at page 106. Lordship got it? 106. Name of the package. Lordship will find SC APC name of the package. Pasighat, estimate cost of the project, cost of the tender, and this is the package. Now, if you see the terms and now at page 111, kindly see 111. This is standard bidding document. Kindly see at page 111. Now, lordship got it, my lord? 111.
Yes.
111 standard bidding
You
document.
come to the relevant.
C 156. 36.36. Clause 36.1. An abnormally low bid is one where the price bid price in combination with other elements of the bid appear so low that raises material concern with the employer as to the capability of the bidder to perform the contract for the offered bid price. 36.2. In the event of identification of a potentially abnormally low bid, the employer, unless otherwise specified in BDS, may seek written clarification from the bidder, including a detailed price analysis of the bid price in relation to subject matter of the contract, scope, delivery schedule, allocation of risk, responsibility, and any other requirement of the bidding document. After evaluation of the price analysis in the event, employer determines that the bidder has failed to demonstrate his capability to perform the bid price and take the bid. So this is what they have to look into it. Now, if your lordship now looks into page, the memorandum, which is at page 247. Kindly see the memorandum of 18th of September 2023. Lordship got it, 247. Yes, I just wait.
You will have to read this 34 with.
Lordship will kindly, 34. I'm just reading
The
34.
employer shall compare the evaluated price cost of all the substantially responsive bids.
Lordship is reading 34.
Yes. there is one-
Comparison of financial.
Hmm.
34.
Hmm.
Employer shall compare the evaluated price cost of all the substantial responsive bid to determine the lowest evaluated cost price.
Yes, all the response substantially declared to be non-responsive.
No, it's responsive. No, that is responsive. What is say it is responsive, but not as the justified rate. Justified rate. It is responsive. They have not rejected on the
Your
ground.
bid is not
No,
been
no, no. They
declared
have not
as a
rejected
responsive.
that. No, no. They have not rejected on the ground. It's not responsive.
Yeah.
It is abnormally. It was low. So when it is
After evaluation.
yes. Now
Otherwise,
30
your bids
Responsive.
bid was found to
yes.
be responsive.
Out of 7 bidders, 3 bidders was responsive. I was also one of the responsive bidders.
Okay.
3 bidders out of 7 bidders.
Hmm.
So now my lord will kindly look into it. So
Page-
if it is abnormally low, then my lord 36.2 and 36.3 they have to look into it.
Page
247 kindly see the memorandum.
247.
See the memorandum. 18th of September 2023.
Hmm.
If you see at 4,
Hmm.
kindly see 4 my lord. Justified bid price ranges category wise to weed out unrealistic very low and excessively high and obstructive bidding. Justified ranges of bid prices of material and works as determined for respective category wise areas shall have to be adopted and adhered to in the bid evaluation process of the tenders and the contract aware thereof for execution department of power as contained in the following respective annexures. So these are the work and see page 248 my lord. 5. These are the category of. Now if you see 5, validity of justified bid price ranges. Justified bid price ranges provided herein as above shall be valid for the bids of tender floated and processed for award during the current financial year 2023-24. These guidelines shall be invoked and operated in consonance with, not in conflict with the provision of Arunachal Pradesh district-based entrepreneurs and professional incentive development promotion act 2015 and rules thereof. So these are the guidelines which has been issued in determining justified bid price ranges category wise. Now, while determining it, my lord, one has to go with the standard bidding document. Suppose I have quoted a price which is very low, then a chance has to be given to justify it. Now, kindly see when this tender was floated, memorandum was issued, there was a pre-bid meeting which was held. Kindly see the pre-bid meeting 261, my lord. See the pre-bid meeting at 261.
Hmm.
See column number 5, my lord. Whether justified bid price ranges of electrical distribution system in AP for various categories as notified by GOP memo dated 18/9/2023 should be adhered to while quoting rate in price bid. Yes, my lord will kindly see yes on the right hand side column. It will be taken into consideration while evaluation of the price bid in consonance with ITB clause 36 of the standard bidding document. This is what my lord, the pre-bid meeting. Their grievances were before the learned single judge that this pre-bid meeting was not adhered to when a subcommittee was constituted. And where is the question of formation of a subcommittee? Now, my lord, tender, if your lordship looks into it, as page 306, it was 3 bidders qualified and it was open, not 12-2, it is 12-3, my lord. I just stand corrected with the date. 306, first 12th of March 2024. Lordship will kindly see. Superintendent engineer to wind power. This is the appellant. With reference to so and so, as per bidder queries and clarification number so and so, and issued memo dated, the e-tender opening board, Marcho got it, found your price bid minus 10.25% below the minimum justified price ranges, which is abnormally low. It was rejected accordingly.
Where it is?
My lord, last line, last 2 lines at page 306.
Hmm.
The tender opening board
Yes.
found your price bid so and so below the minimum justified price ranges, which is abnormally low, it was rejected accordingly.
Hmm.
Lordship got it, Mile? 12th of
Yes.
March.
Hmm.
Now we have written letter on 309 on 12/3, that day itself, 12/3/2024. If you see at 309, we have written a letter to Superintendent Engineer. Kindly see subject, request for giving opportunity for submission of price justification as per standard bidding document. Lordship got it? Now we have given all the materials before them. And if you see at page 311, the last paragraph, hope you will find our price justification in the line with your expectation. However, if you need any further clarification, ready to provide the same as per your convenience schedule. The major factor for the difference between your minimum prices and our quoted price is profit margin. And if you are ready to execute the project by taking minimum profit of 10%, so we don't think that you have any problem. We will deliver the project by saving 10.25% more amount beyond your expectation. It is our point to mention here. We are associated with the ground for more than 20 years. Hence, we better know how a project will execute in hindrance. So this is what we have written. Now, at page 312, when the reply was filed on the same day when it was rejected, the chief engineer written to the superintendent engineer on 14/3/2024. Kindly see my lord. Please refer to your letter dated 26/2/2024, through which the competitive statement of price bid of Pasighat package is forwarded to this office for approval. While reviewing the document, it has come to our attention that the firm quoting abnormally low amounts, that is wind power infrastructure, has not been afforded any opportunity to justify their low quoted rates under clause number 36.2 of the standard bidding document. It appears your tender opening committee rejected a bid under clause 36.3 of the SPD without conducting a detailed price analysis of the bid. In light of this, you are requested to ensure compliance with all the codal formalities outlined in the clauses of SPD, particular clause 36.2, and resubmit the documents immediately for onward submission to obtain government's approval. Now at page 313, he gives an opportunity to us on 14th of March 2024. That is, the SC, on the direction of the chief engineer, has issued a letter to us, to the appellant, giving us an opportunity. Now at page 314, this was an opportunity which was given. 314, this is regarding rejection of our price bid. Again, it was rejected on 22nd of March. Kindly see, my lord, in the second paragraph, you have quoted so and so against so and so put to tender, which is minus 16% below the estimate cost, put to tender 10.25% below the minimum justified rate as per memo dated so and so government Arunachal, which is abnormally low. You may also refer our pre-bid minutes issued on 25/1/2024, where it has been clearly mentioned at serial number 5 that justified bid ranges approved by the high-level technical committee as circulated by the above mentioned memorandum will be taken into consideration at time price bid evaluation of bidder. On the basis of the above ground, your price bid can be rejected by the e-tender opening board. Now on 26/4/2024, my lord, grounds of rejection has been mentioned. This has been communicated, 26. Now this way, my lord, they represented the matter before the government on 21/11/2024. Kindly see at page 318. Because it was not given originally to automated generation, it was to L1, one techno power enterprises. Now, my lord will kindly see, this is interesting, written to the respondent has written to secretary. Reminder and request for re-evaluation of financial lordship, got it? At page 318. Now, reminder and request for re-evaluation of financial bid, implementation of minimum maximum justified rate. Kindly see the third paragraph. In this particular package, it is observed that board members have anyways recommended a bidder whose rate do not fall within the justified rates as outlined by the government. This highlight
a significant lapse in the evaluation process with necessary immediate correction to ensure fairness and compliance with established criteria. Messr DG Construction has diligently adhered to all instruction and our bid remains well within the justified rate outlined by the government. Considering recent development and to uphold fairness and transparency in the evaluation process, we request a revelation of our financial bid to confirm compliance with the established criteria and justified rate. We humbly urge your esteemed office to expedite an implementation of minimum and maximum justified rate for this package as discussed during the pre-bid meeting and outlined in the speaking order issued by the chairman of the board of members. Furthermore, we request due consideration be given to genuine bidders who has quoted rates within the justified limit during this revaluation process. So now at page 320, my lord, your lordship will kindly note this. 320, the chief engineer, kindly note my lord, power central electrical zone. This your lordship will kindly note down. Central electrical zone. He has written to super engineer on 26/11/2024. With reference to subject cited so and so, representation stated tender opening and evaluation under your chairmanship erroneously recommend the bidder whose quote rate falls outside the justified range prescribed by the government. This alleged oversight raises concern regarding compliance with the evaluation criteria and fairness in the tendering process. Such matter necessitates immediate attention to ensure transparency and adherence to the guideline. In view of the above, you are requested to provide a detailed justification for recommendation made by the Tender Opening and Evaluation Committee. A prompt and comprehensive response will facilitate further necessary action. Now, this is on 26/11/2024 by the chief engineer. And on 3rd of January, your lordship, this is important, 3rd of January, the chief engineer has recommended and sends it to the government for approving it. Now, my lord, this 15th of January, kindly one page, I think 5, it is missing in the particular this petition. That's why we file exactly like this, but judgment reflects that it has been, judgment will reflect, my lord. Now, my lord will kindly see 15th of January at page 323. See the 15th of January, my lord. Letter of intent package, so it was issued. My lord will kindly see this is a reference. I have notified % of the chief engineer.
This page 322.
22. This is the same page, my lord. This is 321 and 322 the same page actually.
Recommending the
Page is that is not there also.
Page is missing. No,
But
it's there.
we have a page.
We have-
straightforward.
let's see.
In the writ petition, it is there. Page is missing actually. In the-
Yeah.
Yes.
here on the
No, let's
In the writ appeal.
some
Okay.
In writ petition, it is there.
let's see. in the
where you have been awarded. Where you have been issued
no.
LOI.
No, it has not been issued LOI.
This is what?
It has been
He got the
revaluated.
LOI.
I got, it has
No,
been
no, what
revaluated.
about this, after this? This is page 321 is again in favor of whom?
Not in favor. It is recommended by this chief engineer and send it to the government.
Saying what?
Yes, saying that it should be approved. Recommended it should be approved in favor of the private respondent.
That's why I'm asking. In favor of you.
Yes,
Recommendation in favor of you.
yes,
Page
recommendation.
321.
Yes, yes.
Okay.
And but
LOI
three-
he got.
but 323,
LOI was in his
I'll
favor.
just,
Yes,
323, my lord, 15 January, the LOI was given in my favor.
yes.
Now that was put to check. That has been put. Now, my lord, I'll just point out 2-3 things, my lord.
Just.
Now, my
This
lord
is
will.
3rd
Yes.
January.
Yes, now you
And
see,
you
my
have
lord,
been issued 15 January.
15. Now, 3rd of
So-
January.
So within 13 days,
Yes.
things had changed.
Yes, why? My lord, there is a complaint which has been lodged by normally all the bidders in package, which I said in the opening. And the government decided by a memorandum to constitute a subcommittee for fairness and transparency. Now, very interesting, if your lordship looks into it. 491, kindly see, my lord. Kindly see 491. Now, kindly see 491.
Hmm.
Lordship got it?
Hmm.
22nd of March 2024.
Hmm.
Now, in the interest, Lordship, in the interest of transparency and adherence to procurement procedure under the revamped distribution sector scheme in the state of Arunachal Pradesh, Government of Arunachal Pradesh constitute the following
Yes.
committee for the project titled Development of Distribution Infrastructure under Revamped Reforms Based and Results Linked Distribution Sector Scheme. The committee may also be entrusted with similar examination related to other packages under so and so from time to time. As the case may be, the committee is composed as follows. So these three are the person which may enter: chairman, my lord, from the electrical, power department, finance and law. Lord, you got it?
Yes.
Now, this is when 22nd of March. Please note that number one chairman, who was the chairman of the subcommittee, he was the person who evaluated later on. And he was the person, he knows about the report, but on 26/11, when representation was filed by them, addressing to the chief engineer, this is the same person who was a member of the chairman. He knows about the report, even their name was sent on 3/1/2025. He was the chairman of this particular committee. So when he was the chairman, kindly see the chairman of this committee and kindly see the letter of 26, which your lordship has marked that. That's why I said your lordship will please mark that. Kindly see this. Now kindly see page 322. 320, kindly see, my lord. Kindly see 321 for keep this particular one hand and see 320, my lord. See 320, it's the same person. On 26/11/2024, the same person who was the chairman.
So what's wrong?
But that is what, no, where was there is no wrong. He could not have entertained his representation on 26/11/2024. He has decided that my rate was within the justified rate. Kindly see the report. Kindly see the report of the committee, my lord.
See, if he can entertain others, your representation.
Yes, my representation was not entertained. His representation was entertained.
No, before that.
Before that, where? My representation, because to show that abnormally it was low rate or not.
Yes.
No, thereafter, not in my package, all the package, the subcommittee was constituted. Inclusive of my package was also referred. Kindly see memorandum, my lord. See the report at page 494.
490.
See 494. Kindly see 494, my lord. See the report of the subcommittee. Lordship got it? This report presents the finding of subcommittee to re-examine the justification provided by bidder regarding low price e-tender for revamped distribution sector scheme. The subcommittee composed of officials from the Power, Finance, Law Department was tasked with evaluating the feasibility and reasonableness of the rate of bid received for 6 packages: Rupa, Itanagar, Naharlagar, Namsai, Deomali and Pasighat. Lordship will kindly mark Pasighat. This report details the methodology, finding and recommendation based on a comprehensive analysis of justification provided by the bidders. Now, background, a memorandum was issued dated so and so from the Power Secretary Government constituting a subcommittee. Lordship got it? For re-examining of the justification provisions those in e-tender concerning the evaluation and awarding of the contract of RDSS package. Now, these are the committee person. Kindly see one. He is a chairman. Now, my lord, see re-examination process, terms of reference. Kindly see terms of reference at page 494.
When was this report?
Report is of 15th of July 2024,
Hmm.
15th of July 2024,
Hmm.
15 July 2024.
Hmm.
Now kindly see, no, I am that whether the standard bidding process was followed by the subcommittee or not.
Let us see the findings. What is the finding?
I'm sorry,
Final findings.
final, yes,
Findings.
findings.
Hmm.
See at page, finding at Pasighat, we'll see at page 499, 499. Lordship got it?
Hmm.
See, my lord, on 13th of June, Lordship, kindly see the date at 499 after 5. On 13th of June 2024, one more packages Pasig was ordered for re-examination the justification provided by bidders regarding low prices in the retender by e-computer addition to previously allocated 5 package, bringing the total to 6 package. Lordship got it? Methodology. Bid justification. In compliance with the terms of reference, committee opted to take the justification submitted by each bidder to the superintendent engineer instead of seeking separate justification from the concerned bidder. This justification was submitted to the concerned SC in response to a notice under clause 36.2 or the SBT for the low price bid, which were rejected by the tender opening under clause 36.3 of the SPD. Copies of bid justification organized by package are annex and annex are found for so and so. Now summary, kindly see. All this was analysis. All this was analyzed and see at page 502, my lord. Your lordship want to see 502 summary. See summary of findings. Discrepancy. Lordship got it? Upon detailed scrutiny of justification provided by bidders to SC cum chairman of tender opening and evaluation committee, in response to inquiry under clause 36.2 of the standard bidding documents, copy of justification available to so and so, significant deviation were identified between the item-wise market rate derived by the committee and the item-wise breakdown cost justified bidder except for Rupa and Deomali packages, where the bidders have not provided item-wise cost breakdown claiming to be the manufacturer. A detailed analysis comparing item-wise justified rate provided by bidders and the rate derived by the committee through a market survey is available in the Excel sheet. Item-wise rate analysis market so and so. In this regard, it is pertinent to mention that even the bidders who have provided item-wise justified rate have not indicated the overhead expenses, contractor profit, transportation charges, freight and insurance separately. Hence, the committee considered the cumulative price quoted in the bids by the bidder for determining the capability of bidders rather than on the basis of item-wise justified rates submitted. A summary of comparative analysis highlighting significant discrepancy between the market rate discovered through the market survey and the bidders quoted by documented below package-wise. If your lordship, all the packages, if you see 6, my lord, the petitioner, the appellant, Pasighat, the rate discovered through the market survey amounting to 47.02 crores, while the price quoted by lowest bidder, the appellant, is 54.99 crores, which is 16.96% above market survey rate. So my rate was workable 16.96, the market rate. Now kindly see 506, kindly see the conclusion, my lord, 506. Kindly see 506, my lord. Conclusion and recommendation. After a thorough re-examination of the justification provided by bidders and a detailed market analysis, subcommittee found significant differences between the market rate discovered through the market survey and the prices quoted by bidders. The finding indicated bidders quoted higher rate than the approximate landing rate determined by the subcommittee. Therefore, regardless of their ranking as L1, L2, L3 or L4 in the auto-generated price schedule, the bidders appears to have the capability to perform the contract at the price quoted by them in relation to the subject matter of the contract scope, delivery schedule and allocation of risk. However, it should be noted that in Namsai package, Accurate Enterprise has quoted minus 3.84% below the approximate landing rate determined by the subcommittee, raising concern about the ability to fulfill the contract requirement. My lord will kindly see now, this is signed by the same chief engineer. Kindly see at 506 on the right hand side of the column. Now he says the my rate is the workable rate because 16.84. After a sub,
Subcommittee only examine your
Yes,
bid, your
ye-
bid,
yes.
not the others.
no, others also, not my rate, other packages, my 6
Not
packages.
packages. The other bidders.
Yes, all bidders was not my, all bidders was taken into consideration. Not that alone my, then it is illegal. My lord, my rate, when the committee said, if singly it has taken my, then it is illegal, my lord. Then they can't do it.
Committee has examined and come to this recommendation after examination of all
Yes.
the bidders
Yes,
of Pasigat,
yes. Kindly see,
including the bid of the price bid. of,
correct,
the-
my,
the
yes. My
respondent.
lord, 505, it will see, 505, all the bidders,
Hmm.
505 in Pasigat, kindly see, Pasigat package. All the bidders, 505 Pasigat package,
No.
abstract of analysis,
Okay.
all, my lord. It is not that now, why this, his representation was considered by the same engineer. And my lord will kindly see one thing, 507 kindly see, it was within the knowledge. And 506, see the file noting. See that, my lord, chief engineer on 5, kindly see, as per the report submitted by SC, which may be seen at so and so, and this Pasigat package may be placed before the screening committee formed by the state government. White memorandum dated so and so, 29/5/2024. Please, this is 5/6/2024. And kindly see the same as suggested, note number 16, as suggested by chief engineer, which may be seen at note number 15. Approval may be given for placing the Pasigat RTGS package of screening committee, please. Now see page 508, note number 21. Note number 16 may kindly be considered for approval. It is within their knowledge. And when the representation was filed, what was it?
So on the basis of the subcommittee, you have been issued. the
Yes,
LO.
all, yes. And while his case was considered singly, his representation was filed on 26/11/2024. Chief engineer knew about, he was a member of the chairman.
Have you challenged that?
Well, no, they should have challenged, my lord. Their duty, my lord. They did
No,
not
no, you
challenge the
said-
memorandum.
You said.
No, I did not
you
challenge,
said
my lord. I did not challenge it, my lord. It is a-
Singly, his case has been considered and recommended.
No, that is not ultimate order has been passed. It has to be sent to government. Government has given in our favor. So there is no question of challenging it, my lord. The government is in our favor. Government
So
has passed.
Proceedings were going parallelly.
No, yes, it was going on, my lord. From it was going
The
on.
chief engineer is having these two left and right.
Right. That's the case.
For what?
No, one
I-
second. I will see. That's the whole case, my lord. It is apparently on the face of record. I don't want to say much. That is why I said, please mark that. Being a chief engineer and you are a member, chairman of a subcommittee, then he recommends his name on 26th, on 3rd of January. And he directs the superintendent, please go ahead. And you know the report, you signed that. And you said the rate which is considered is, now my lord has to look into public interest is paramount. Now the rate which he has
But
quoted,
this subcommittee, this report is of which date?
15/7/2024,
15.
7/2024.
And your this recommendation in favor of the petitioner is
3rd of January 2024,
3rd of
2025. But recommendation,
Whether this recommendation has been accepted?
no, it
by
has not been accepted. That is why it has been given in my favor.
No,
15th
no,
of,
accepted. I mean, once the report and the recommendation is, who has to accept?
no,
it?
that
it
is why the government has to accept the proper, it has to be approved by the government.
Has
Now,
it-
my
has it-
lord,
Has it been accepted?
no,
Approved?
his is not been accepted.
No, no, about this report.
Report has been, that is why this order has been passed, my lord.
Order, whatever.
LOI.
Recommendation.
Yes, recommendation, definitely it has been
Let
accepted.
us
The
see your
government will say,
LOI.
yes, my LOI kindly see 15th of
Page.
January,
Page,
yes. 323, my lord.
hmm.
See kindly, my lord, this is a reference is notified in person of chief engineer power. Lordship got this? As approved as serial number 1, above your offer vote of the development of so and so, dated and accepted on behalf of governor as quoted, rates amounting 54 lakhs, 54 crores so and so. Only a detailed scope of was given in so and so. You are request. So this is the rate which was quoted. Your lordship will find in the report. In the report, this is the rate which I have quoted. My lord, I am telling your lordship, it is, if it is not as per the report, then of course, my lord, yeah, I don't have a case if it is not on the basis of a report. Report was forwarded to the government.
No, this page 0, the 321, it's
Yes,
incomplete.
yes, that's why I've said, my lord, it was,
How do we know that it has been recommended?
no, his name.
From
In
where
the
we get
judgment,
it? The complete.
no, it is judgment. 51 is a judgment,
It is
kindly
page-
see. Yes. Sorry for that, my lord, is an
This
inconvenience.
is the writ petition.
And I'm asking you.
They have not annexed the writ petition
Chief,
with
it
the
is there,
annex.
this is the writ petition.
Which page? No, they,
Yeah, just-
have they not annexed it in the,
My
Page
lord,
number?
in the writ
Page?
petition, it is annexure 15, page 218 and 219. 219 is the last page.
218.
And lordship will take note of the fact that the chairman of the tender opening board is superintending engineer.
218.
It is not the chief engineer.
No, this,
Superintending engineer recommended me.
this is not a
And
part,
subcommittee,
1 second, this is not a part of the writ petition we are holding. 2 pages which are given 218 and 220,
Sir?
290, no, मेरे पास नहीं है, इसलिए हम बोल रहे हैं.
maybe there was.
Now I will say something, with things in-
No, Papa, you
then,
never do that.
then that's why I'm saying.
But it maybe
Yes,
there was
ठीक
a
है.
mistake, maybe clerical mistake,
Yes.
but before my lords, in the
Yes.
report, it was complete. Maybe accidentally.
anyway,
Yes,
recommended by the chairman
yes.
of the tender
And the
opening.
superintending
company.
engineer.
And my lord, how a report, now the government has to say, if it is not in person report, then it's a different thing
Okay,
altogether.
understood.
Yes, your
So
lordship,
according to you, whatever has been done, as per the board, which is permissible
yes,
in view of the decision of the government
yes,
to have the board
yes,
re-examine
yes.
in terms of the clause 36.
Yes, point. And it was fairness and ever transparency. And my lord, public interest, my lord, public interest has to, the award of the contract,
We wonder how these parallel proceedings could go. Because
yes,
the report, according to you, of the subcommittee is 15/7/24.
correct, right.
And recommendation is 03/01/2025.
3-1.
And 03/01.
Yes, correct.
And you have been issued the LOI
Hello, and how,
on 15.
no, on 15, that is why I'm saying,
According to you, how it
how
affected?
it, can- how, when 15/7/2024, he was the same person, was the chairman, and he conclusion is that it is workable. My market rate is
As per
workable.
The recommendation is chairperson is the chairman. Is
Same.
No,
It's not
superintendent
same.
Yes,
engineer,
kindly see.
Not the chief engineer.
Your lordship will kindly look into it, my lord. I'll just look this. So,
Chief
Okay,
engineer.
we'll find out from the
yes,
government, who is the chairman. But as per this page 321,
yes,
recommendation in favor of the writ petitioner is by the superintendent engineer, chairman e-tender opening board.
no, my lord, what I am saying, that when
He may
this
be chairman of the
No.
subcommittee.
chairman of the sub chief engineer, so when the representation chief
But-
engineer,
Opening
Chief
board
en-
chairman is
see
the
at page
superintendent
3
engineer.
no, see 320. the chief engineer ought not to have entertained his repetition also, 320. Kindly see 320 at page 320.
He forwarded.
No, let me say, he could not have forwarded. Kindly see 320. Where is the question of forwarding when you are, you knew about the report? Kindly see at page 320 that this is a chief engineer power, same person, Central Election Zone on 26/11/2024. Address to SC. So where is the question of say, reminder sending it to SC when he knows about the report? He could not have sent it. That means they went and they met, whatever, let me put a very crude way, they went and met. And this is what has happened, my lord. Kindly see, my lord. Same person. And the person should not have written to SC and he should have in fact informed them. Sorry, I will not entertain your petition because already there is a report which has been furnished to the government. And in one of the writ petition, my lord, Rupa package, which was dealt by this honorable court, Rupa package, kindly see.
In that case, the single judge has held that on the submission of the government council or the standing council that they are constituting a committee.
Yes,
In that, we're not concerned.
I'm sorry.
We're not concerned.
Yes.
It's Rupa package. It clearly there is a funding. Is it a
No, it is all-
erroneous funding?
And my
finding
lord,
or
what has happened in all the packages, the abnormal law, there was a complaint. But this Pasigat package was sent later on. 13 June 2024, it was added. Because all was abnormally low. So this rate was also low. 13th of June 2024, if your lordship looks into it, the report which was sent,
Para 35, it's clearly is given.
yes,
As regards the writ petition 179,
yes.
admittedly not for this package, but for the Rupa package.
No, that is only Rupa packages inclusive, all the packages inclusive which was later on it was sent. 13th of June 2024, this Pasigat package was sent.
Anyway, we're not concerned.
Well, we are concerned about this package only.
Court has said that it was not as per the direction.
Now,
of the-
I'll tell your lordship, what is the error that has been made by
but
the
it
learned.
was only conveyed that the government has constituted.
Now, the
subcommittee
government constituted
in
this
that case. for
subcommittee,
Rupa.
no, on Rupa, not all the packages, my lord, we are concerned
We'll see-
about,
we'll see to that.
yes, we are concerned with the Pasigat package, my lord. Now, my lord, the constituent subcommittee is, my lord, consonance with keeping in consonant 36.2, 36.3. They have not deviated. This is what? Justified rate has not been deviated.
See. Yes. In fact, we should listen, hear him first.
The lordship may hear him, but government, I believe, is sailing along with the appellant. So the contrarian view would
It doesn't
certainly
matter
come from the respondent one.
whether this ceiling or they are
Very well.
selling or
Lordship may hear them first. Lordship may hear them first. Should I?
Yes, my lord.
How can you have a parallel proceeding?
Yes, my lord. That
You are the
I,
chairman of the committee examining all this thing and then
that,
you submit a report. Again, you said,
that past query, my lord, I will try to answer, my lord. My lord
Yeah.
will kindly have a look at page number 420, my lord.
420.
420, my lord. Four two zero, my lord.
Yes.
420, my lord. Second part, I am reading, my lord. Part of the petition assertion that the selection process was lost in favor of respondent 9 is completely baseless. The tender process began on 17/1/2024. And due diligence was followed at every stage, including the formation of the Regulation Committee on 29/5/2024, submission of a report on 15/7/2028, the government approval on 8/1/2025, my lord. My lord will kindly note, my lord. So report, my lord, was furnished 15/7/20, was approved on 8/1/2025 only, my lord.
By the
No.
government.
Yes, my lord. Government. Now, my situation, my lord, as my parallel proceeding as a civil engineer, my lord will see, my lord. He was the civil engineer, my lord. 2%, my lord. And he was the chairman of the subcommittee, my lord. Now, in such situation, my lord, that
You have to act like a true person.
Surely, my lord.
One as a chief engineer,
As a
entertaining and the
subcommittee
according to process.
process, my account for now.
Any grievance, any
Yes,
application
my
that you have. And as a chairman, you will have a different.
Different. Now, once my lord
What to say
tender
and
chairman
different-
committee, my lord, recommended my lord, I need to place that before the.
That is
say-
very strange, sir.
No, suppose I am
You
assuming.
have two roles, but then
No, suppose my,
for one purpose.
no, my lord will say, my lord. I am assuming a citizen. Suppose one,
Yes.
here, my lord will kindly appreciate, my lord, the tender evaluation committee in term of the NIT was the SE, my lord. Now, one there is a recommendation SE, my lord. It is not, my lord, I humbly believe, it is not favorable on my part to, my lord, stop the process there, my lord. As a chief engineer, my lord, because as a chief engineer, my lord, is this tender amount need to be appropriate by government, my lord. I need to place that before the appropriate person, my lord. Accordingly, my lord, when this private respondent, my lord, was recommended by reevaluation by doing review the tender committee, my lord, I recommended to the government, my lord. At that point of time, my lord, till that, my lord, this my report, my lord, as a subcommittee member was not approved by the government, my lord. Now, how I can, my lord, before approval of the government, my lord, competent authority, my lord, can stall the process, my lord.
It's okay. Recommendation may not be, it may not be final, or government may not
Yes,
accept
my
the
lord.
recommendation.
Yes,
But
my lord.
it has to be the justified reasons why it has not been. Otherwise, the meaning of having a tender opening committee,
That my my
they
situation,
will
I
look
mean,
what is the best, and then accordingly they'll recommend.
yes, my lord.
Unless you have a very justified reasons, how you just can just because you are the approving authority, you just can reject it.
Yes, my lord. I am not the approving authority, my lord. My role is middleman, my lord.
You are a middleman.
Yes, my lord.
Appears to be.
No,
What
my
do you mean by middleman?
Yes, my lord. I am the middleman between the tender committee.
Middleman has got something, some connotation, different connotation.
No, my lord. My lord will see the
How
city.
can you be a middleman, chief engineer? That is where that's the strange thing here.
No, my lord. In
You
term,
act as a middleman.
my lord, let me explain. My lord. Give me a chance, my lord. That in term of the NIT, my lord, the tender evaluation committee chairman of the tender.
The words which you have used, middleman.
Because
What
my
do you mean by middleman?
I mean to say, my lord, I'm in the mid of the my lord process, my lord, by the secretary government, my lord. Ultimately,
Don't use that word.
my lord, my humble submission, I'm not the final authority, my lord. In terms of the NIT also, I'm not the chairman, my lord. In terms of the NIT, the competent authority, my lord, for approval is the chairman tender board, my lord, that is SE, my lord. Now, once he has recommended, my lord, I'm in the mid of process, my lord. This need to be approved by the government, my lord, not by me, my lord. I need to place that before the government, my lord.
You are a duck runner.
In
Or a
this
post
process,
office.
at least in this process, my lord, I humbly believe, my lord.
You are a post office.
In this process, my lord, because, my lord, once I become a chairman of the subcommittee, my lord, and one I have recommend one thing, my lord, on that basis, my lord, that it till that approval of the government, my lord, I acted that directly rejecting the recommendation of
It
the.
appears that you are more interested to act as a chairman of the committee than rather than to perform your duty as a chief engineer, which is your substantive post.
Yes, my lord.
Yes.
No,
Is
no,
it?
my lord, can you do whether I'm
strange.
able to explain my lord or not? So my lord is think the situation, my lord. If suppose once as a subcommittee, my lord, I have chairman of subcommittee, my lord, I have recommend something, my lord. Until that is approved by the government, how I can withhold the normal process, my lord, in terms of the NIT, my lord. NIT, the ultimate authority is the chairman tender committee, my lord. He has approved one thing, my lord. How I, as a merely a chief engineer, my lord, can withhold that process, my lord. I need to place that the recommendation of the subcommittee, my lord. Oh, sorry, my lord, tender board to the authority, my lord. That I have done, my lord.
That you have done.
My lord.
Knowing fully well that there is a decision of the report and recommendation of the,
Yes, but the
recommendation of the.
committee, my lord,
committee.
subcommittee, my lord, but yet to be approved by the government, my lord. That was approval on 8/1/2025 only, my lord.
Have you
I-
placed that, recommendation?
Recommendation, our report
In
is on
favor of-
15
In favor of the,
private respondent, my lord.
yes, brief petitioner.
Yes, my lord. Now,
Have you placed before the government?
yes, my lord.
If you think that, if you say that you are the middleman, only the postman. who
Yes, my
just
lord.
Posted to the.
Yes, my lord. We have placed. Yes, that's why, my lord. They are saying, submitting against that only, my lord. That's why I'm explaining, my lord. Once as a chairman of the subcommittee, my lord, I have recommended something, my lord, in favor of the petitioner. my lord.
Recommendation is of 3rd of, January.
No, first, my lord,
3rd
our
of
report is on
January.
15/7, my lord.
Huh?
Our report is on 15/7/2024.
Yes.
Wherein
Then,
we recommended in favor of the appellant, my lord. Appellant, my lord.
that is, huh?
15/7.
It's okay, 15/7, and then, it was approved on 8/1.
8/1, my lord.
Huh?
Yes, my lord.
8/1 by the government.
My lord. In
And
between,
then- And then,
in between, my lord.
in between 0301,
Yes, my lord. In
3rd of
between
January,
tender evolution committee, my lord.
they have recommended his, in his.
Private response.
Private,
Now,
In
I
private-
as a chief engineer, my lord, I placed it before the government, my lord.
When?
On that, my lord,
Who is for the government?
3rd January.
Who is for the government? Anybody appearing for the government? Government is there.
I'm, my lord.
Whom you are for? Are you for the government?
My lord, my lord.
You are also for the government.
My lord.
Yes. So first you are now on defending the chief engineer.
Yes, as a chief, he's part of the
Okay,
government, my lord.
chief engineer, okay, we have understood. And then this recommendation was sent to the government. Recommendation in favor of the petitioner.
It was on 3rd, my lord, 3rd January.
Huh?
3rd
How
January.
did by the SE?
Yes,
How
email.
did by the SE?
Yes, my lord.
I think we'll finally we'll hear it and dispose it. Not today, maybe after a week. It appears it rested on that only. If it is rested on that with you,
My lord.
if
Yes.
you said you are the post office, postmaster,
My lord.
if you have not delivered it to the destination, you are penalized. You will be penalized.
My lord, maybe, my lord, so.
And it creates a doubt again, more doubt. Because you just want to stop it and get it done. Where you are interested as a chairperson.
No, my lord, I humbly, I did not stop it.
No, appears to be. I just,
My lord.
as per your, the conduct and as per the facts of the matter,
My lord.
which you have projected.
It did.
It's okay, you find it out. Yes.
Hmm.
What do you suggest? We'll admit the petition appeal and we'll hear it after a week for we'll finally dispose it
Give
off.
me 5 minutes.
Yes.
I may clarify many of the doubts,
Ah,
or maybe, my lord, after looking into those aspects, my lord may not be inclined even to admit that it's a writ appeal.
sir,
Just subject to.
prima facie, because these are because you'll be arguing on the merit also today.
Uh,
Are you enter into the merit?
I'll enter into the matter.
Because it's
only to the
admission stage, that's why we
I will
have
enter-
heard the senior counsel some land.
My lord,
You
my
are the,
esteemed
of course,
colleague-
I understand.
I got it.
You are the
My lord,
caveator, equally you have a right. What we suggest is,
Ah,
let us admit this. We'll list the matter after a week for final disposal.
my lord, in that case, could
Because
it
it's a
be,
writ appeal.
my lord, could it be, my lord, straight away, because,
Because even if we understand it's a tender matter, public importance is there, but then learned single judge has directed
because,
to award the contract to the eligible bidder.
my
Not
lord,
particular.
could it be on 30th June itself? It's
You
Tuesday,
suggest-
Tuesday, my lord, I'll be here before my lord and we can finish it off.
Yes.
But my lord, certain doubts I can clear right now.
Yes.
Because prima facie,
So
very short,
would it-
prima facie,
within 9 minutes.
maybe within 5 minutes.
Yes.
I'll finish it off.
Okay.
Since my esteemed colleague has prima facie showed his case to your lordship,
Hmm.
prima facie, I will show the case of respondent one before your lordship.
Yes.
First of all, my lord is false clarification.
Hmm.
Lordship has already noted the fact that the tender opening board, the evaluation committee, which re-evaluated my price bid, the chairman was superintending engineer. Whereas the subcommittee is concerned, the chairman of the subcommittee was chief engineer. They are two different persons. Chairman, yes, it is true that I submitted it because when nothing was happening, what happened was, this date is relevant, when the price bid of respondent 9, the appellant herein, was rejected on 22nd of March 2024. Thereafter, my lord, only on 29th of May 2024, the memorandum is issued and a subcommittee was constituted under the chairmanship of the chief engineer. And thereafter, nothing was happening practically, my lord, for nearly 8 or 9 months. When nothing was moving, nothing was happening for 8, 9 months, I submitted a representation to the chief engineer urging, have a relook into my price bid. I do fulfill the requirement. He forwarded it to superintending engineer tender evaluation board, said, look into it. He looked into it and gave a
Just a
recommendation
minute.
in my favor.
Just a minute. It just clicked my mind. Where is the L1?
My lord, this question was
And
asked,
just
unanswered.
out of the
And
context.
for my lord, for some strange reason, went out of the fence. He withdrew the earnest money. He lost interest in everything.
That's why I just wanted to know.
He lost interest in everything, withdrew his earnest money.
Because it doesn't say anything
Yes.
in the judgment.
My lord Justice maybe
Nothing has been said.
my lord Justice maybe asked the same question. He withdrew the earnest money and lost interest in everything. So he
I think
lost
it's,
the
but then it's not recorded in the
It is not.
judgment.
But
Yes, yes.
certainly the question was asked, it was answered.
Yes.
In the presence of my.
Of course, it is not required.
Yes.
But we would like to know where he has gone,
Yes. We
I
don't
mean,
know.
when
He
it-
withdrew the earnest money.
where he has vanished.
He withdrew the earnest money. He lost interest.
Yes.
So he's no longer in the picture. So, this is what it is. It was re-evaluated and the recommendation was made in my favor. The recommendation was made in my favor on 3rd of January 2025. I was, with great expectation, I was waiting for the fruit to come to me. LOI went to him. And this is what was the trigger. And trigger resulted into a writ petition filed by us. Now, in the writ petition, my lord, what was under challenge? In the writ petition, number 1 under challenge was the very constitution of the subcommittee. The argument was the subcommittee could never have been constituted. It is not the part of the NIT. It is like changing the rule of the game after the game had begun. This was the argument. Number 1, subcommittee was challenged. Number 2, its recommendation was challenged. Number 3, their LOI was challenged. Now, all these aspects were looked into by learned single judge. And learned single judge came to the conclusion, number 1, that subcommittee was illegally constituted. It amounted to changing the rule of the game after the rule had begun. Learned single judge placed the reliance on the loco classicus, we call it, not International Airport Authority, because in a pre-bid meeting, the decision was to abide by the guidelines of 18.923. Learned single judge held in the pre-bid meeting, this was a decision. This has to be read as the integral part of the NIT. You have to act in accordance with that. You cannot deviate from your own procedure and constitute a subcommittee thereafter. So this is number one.
But Sir, we may not agree that the government cannot constitute a committee. Looking at not only this particular package, constitution with the committee,
But
if it has to be in accordance with the clauses in the tender SBT. Because they said, I don't know, we have not gone deeper into, but then it is as per the clause 36.2.
I'll put it.
So
So
just
for
because
clause-
the government has the authority to approve it, government is the
answer
final authority,
I'll answer it.
and to walk out, looking into, it's
My
not to
lord,
favor
my lord
anyone.
would have been- My lord would have been 100% correct had 18,923 memorandum of the Department of Power, which was read by learned single judge in conformity with the NIT, had that
Yes,
18,923
That
memorandum,
you may have a point, we'll have to
had
determine that.
this 18,923 memorandum not provided for all the rates, there was a chart. And in the pre-bid meeting, it was pointed out very clearly that these rates will be looked into for the purpose of finding the justified rate. So, my lord, when this was done, there was no justification for constituting a subcommittee in conformity with the clause 36. Clause 36 speaks of abnormally low bid. Clause 38 speaks of most advantageous bid. And clause 34 provides for evaluation of bid. Now, this, my lord, evaluation has to be in conformity with the justified rate provided by 18,923 memorandum of the Department of Power. This is categorical finding of my lord learned single judge. And this is what was deviated from. That is why, my lord, it amounted to changing the rule of the game after the game had begun. That's the first submission. Likewise, my lord, the second part also comes in. There is a deviation from the procedure which they promised to follow. So therein comes the principle, my lord, laid down in International Airport Authority's case. Now, my lord, thirdly, the recommendation which was made in our favor in the re-evaluation exercise, that recommendation was never challenged, my lord, by anybody. It was never under challenge. The learned single judge, my lord, also found fault with this entire exercise. Because what happened was, my lord, this was
A recommendation, he may not challenge it.
Second,
because it's not binding on the.
But after the price bid of the appellant was rejected on 3rd of January, the same, my lord, was altered and a new fact was created by virtue of the recommendation of the subcommittee. What could not be done indirectly was done by way of the recommendation of the subcommittee, and LOI was issued to him.
No, according to him, this subcommittee is as per the clause 36.2.
My lord, if the answer is because clause 36 cannot form the valid basis for both, my lord, the justified rate as well as the justification for the very existence of the subcommittee. It is precisely, my lord, for clause 36.
If 36 has to be followed, why not the
Below 36?
tender evaluation committee?
Again, possibly it's my fault. I could not make myself clear to my lord. It
No.
is precisely for complying with the requirement of clause 36 that there is memorandum of 18,923.
Okay, well,
18,923 memorandum provides for all the justified rates. So therefore, my lord, as to whether in a given case a bid is abnormally low has to be ascertained by looking into the chart, which is there, my lord, in the memorandum of 18,923. And my lord, it is in the pre-bid meeting, it was unanimously decided
Yes.
that 18,923 memorandum will be followed for the purpose of finding the justified rate. So, my lord, there is a deviation from that path.
okay.
So, my lord, the necessary conclusion.
Deviation by the
Comment?
committee.
My lord, deviation, but I would rather say deviation maybe by a government by constituting a committee. Why do you constitute a committee? If that be the case, you are practically turning the entire system. You are moving the clock backward. You yourself say 8923 memorandum is there. You yourself say there are justified rates. On the basis of those justified rates, you find out the abnormally low bid.
No, that's what I'm saying. If they want to go it scrutinize again,
Then in that
why not the board?
then in that case there has to be retendering. You can't, my lord, because we gave our bid, keeping in mind
No,
the memorandum of
I am in your favor right now.
what?
If it has to be revisited, why not by the tender?
Yes.
Constituted
Yes,
tender
correct,
board,
correct, very good,
public tender board, who has recommended, who has sent this, who has had the
No.
findings of it.
No quarrel with that. So that is why, my lord, the view of learned single judge is a very reasonable view. No second view is possible. And herein comes the principle. When the view taken by a learned single judge is a very reasonable view, then merely because
Tentatively, why not the against the constitution of the board?
my lord, but the problem is
They may not be illegal in constituting the subcommittee, because it's not for one
subcommittee
case.
can be for other cases. But there is another facet of the case, because even the recommendation of subcommittee was not unanimous, was not across the board followed. There was no
Yes.
uniformity in following the recommendation of subcommittee. There is a clear finding of the learned single judge. Learned single judge looked into the various packages
I
and
think-
found,
Both of you, we cannot find fault on both of you.
Lord, since the learned single judge
Obviously,
has given
obviously, both of you will do your best.
my lord,
To
could it be that,
to
very well, my lord, we'll go
get on
across
board.
We'll go
But
deep
then
into the case.
we'll have to see how they have.
Very well. Then could it be on 30th of June? Please,
Can it be on 2nd of July? Let it be July, 30th June, itna jaldi hai.
you
2nd of
work on
July?
it. Then we'll have to admit that I think.
No,
it will
holiday will
take
become
time.
30th, I have this. The 2nd of July?
My lord, 30th of June would be.
No, I will not be.
No, you work on it. Then we have.
Okay, yeah. 2nd of
But then
July,
that's-
Tuesday.
We cannot at least.
2nd of July.
All right.
2nd of July.
2nd of July. All right, yes. Second of July. Yes, 2nd of July.
It's Wednesday.
All right.
Admit किया है.
Yeah, ठीक है, but my lord wants to go deep into it. What's the point? It's okay. My lord, there's another aspect.
Yes.
There is an admission by the government, which was duly recorded in the impugned judgment by the learned single judge,
Yes.
that yes, government concedes that the constitution of committee is not in conformity with the pre-bid meeting in the NI, the terms and conditions of the NI. That is categorical finding of learned single judge, recording the admission of the government. My learned friend has been quoted. Yes.
Your learned friend might have wrongly admitted.
My lord, that concession, whether it is a concession.
We'll go
legal
by,
concession,
we'll go,
legal
we'll
concession,
go, my lord. We'll go by the
Very well.
records.
Let's look into
Epi-
all the facets.
epidemic, my lord, have a look, my lord. Yes.
No, we'll- we'll-
Particular question was asked, my lord, whether there is mention of subcommittee or not, my lord.
Huh?
That particular question was asked to me, my lord, whether the mention of subcommittee is there in it,
Sir,
that I consider there is no. But epidemic, there is mention
we'll-
of this
We'll
whole
hear
other
on
point.
next step.
Second-
You be ready with all this.
My lord, but my only fear is, since my lord, ultimately it is the government which has to decide, and there is no positive direction as such in our favor, because under single judge already said,
Yes.
the due process shall be followed. So therefore, my lord, they let the
To our-
court in order.
No, no,
let
that
the
is-
matter be heard on 2nd of July.
Why you, that is, you said before I started.
No, no.
No
we'll-
interior,
we'll
it's up
say-
to the
we'll
court.
say-
They will not proceed, yes, they will not proceed, they will not proceed. They will not proceed.
Can't be compared.
No, they will not proceed. My lord, it is the midst of your lordship, they will not proceed. With the observation that has been made by the learned
No,
single
had
judge.
it been.
Status quo on today shall maintain.
See. Learned single judge has directed to award the work to eligible bill.
No, I know, your lordship is
Now issue is, yours is LOI,
here.
that has been set aside. Writ petitioner, his name is recommended. So there's another stage is there where the government has to agree it or not. It has to be first approved.
No, this is,
I think
no,
that
no,
will
my lord,
I'm sorry to say, it has been issued in my favor
Yes.
on the basis of report.
That has
His
been set
recommendation has not been approved.
No,
His-
that's what I'm
That is
saying.
under examination by this court now. Because learned single judge has set aside the order, LOI.
Hmm.
Now we challenge it. It is now consideration before the learned
So
single
we'll
division
say-
bench.
Will not.
So they will not go ahead with the process. That's what I'm saying. Till 2nd of July. That's why. How it makes a
Yes,
difference?
what do you say?
They will not go ahead with the process.
Are you on the, are you, awarding the award?
My lord, if no, my lord, the order is passed, my lord, we need to comply the judgment of.
That's
the
the
bench,
way.
my lord.
No process, my lord. That is what is important. Let us status quo as on today shall maintain.
Heard,
Here, here.
heard, Mr.
Uh,
The Das, learned senior counsel, assisted by Mr.
K. Mohammed.
Learned counsel for the appellant. And also heard Mr. PKT were learned senior counsel assisted by Mr. A. Sharma, learned counsel for the respondent number.
Vacation will be around the corner.
Actually, you find out,
Yeah.
observe if this bench, I mean, this thorough bench, the practice.
I think
is-
the 2 weeks
as in
is there.
when there is
It's there, 2
a
weeks.
fixed matter, DB has to be.
No, 2 weeks. Yeah,
That's
yeah. See. It's there.
Decide not, they could not really demonstrate the illegality in the judgment of conduct.
We'll see, we'll see. It requires detailed hearing and deliberation and consideration. This intercourt appeal filed by the appellant is directed against the judgment and order dated 23/05/2025 was by the learned single judge in WPC 48 of 2025, whereby the LOI issued to the appellant. You give the date of LOI here. That is page, LOI is page
LOI is at page. no?
322.
Yes, 320.
Hmm?
322. Sorry. LOI is not 322, 323.
323.
3.
15, huh? 15/01/2025. That is when so. Pertains to. Work of development of distribution infrastructure under revamp reforms based and result linked distribution sector scheme in Eastern District. Package number, huh? Page 323. Pursuant to the NIET,
NIT.
which date?
It's,
NIT?
it is
17
17/1/2024 at page 106.
And directed the state authorities to award the work. Remanded, sorry, and thereby remanded back the matter to the department to allow the work to the eligible bidder strictly in accordance with law. Within a period of 45 days from the date of receipt of certified copy. The orders. Admit no formal notice is required as the learned counsels are duly, as all the respondents are duly represented. We'll discharge the caveat. Caveat is there.
Yes.
In caveat, you discharge the caveat. Caveat discharge, stands discharge. When the 45 days is
I'm sorry.
expiring, 45 days,
Oh, 45 days will expire. On the date of the judgment is on 23/5/2025. 23/5/2025. July 7. That's why I'm saying they will not allot. They will not allot to the eligible bidder. They will not allot.
45 days will be over. only
Whatever,
after
my
end of
lord,
July.
you don't know, my lord. We don't know, my lord.
we'll say that. As agreed to by learned counsel to the parties and considering the matter relates to
May I not?
what is this actually the electrification?
Yeah, electrification.
Electrification which is in the public interest. Let this matter be listed on
2nd of
2nd
July.
of July
Yeah.
2020. In the meantime, the respondents are directed to maintain
Status quo. Yes,
as far
I'm
as
deeply
the
aware.
tender is concerned.
I'm deeply aware.
Doesn't make a difference.
Yes, only
It will expire on the 7th.
only.
My lord,
Yes.
so this appeal arises from the impugned order dated of 7th April, my lord, 2025, whereby the learned single judge has rejected our impleachment application in the writ petition filed by the respondent, my lord, the private respondent. The subject matter in that writ petition, my lord, was regard to a land compensation, my lord. Now, his lordship said that since the appellant's villagers, my lord, Yobin community, my lord, does not fall under neither of Ampen village.
Why it is listed for today?
But it is an appeal because it's in the order. It's
Order, so it's
on the
why
prayer-
listed for what?
in the prayer of my learned friend, it was listed today, perhaps for filing objection.
Yes. Are you filing objection?
Sir, appeal, my lord. So from the perusal of the records, my lord, to show that this appeal is not regular. I'll be objecting on two grounds. Two, my lord. First, my lord, is technical. Second, my lord, on merits. My learned friend on merits, my lord. In the IA, they say that they are villagers. If my lord comes to page 25 of the.
No, what I'm asking, why this is listed for today? It's orders.
I have entered appearance, my lord.
You today.
I
You
found
have-
the Kaladama payment.
If you have any objection, you will grant you because listed for admission.
My lord.
For right.
Definitely, my lord.
Heard Mr.
P. Yobin.
We have been learned counsel for the petitioner. G of it.
Appellants.
Learned counsel for the appellant and Mr. Next paragraph. Who is the 1, 2, 3?
1 and 2 are here.
Huh?
1 and 2 are.
I appear for 4,
Mr.
6 and 7, 7 and 8.
No, it's okay. Mr. Petitioner, learned counsel enters appearance on behalf of respondent number 1, 1 and 2. Mr.
I'm
Yeah,
for
that's
4,
and-
6, 7 and 8.
And learned additional advocate general appears for
4,
state respondents.
State
State respondents. 4, 6 and what?
6, 7 and 8.
Your Honor, I'm on behalf of Mr. M. Kato for respondent number 3 and 5.
So and so. Huh? And got to learn counsel for the learned GST for state for Union of India. Huh?
Well, just to bring, I'm sorry.
Service complete. Services are complete. List for admission after 2 weeks.
Just to bring to my lord's notice, the writ petition is listed at court number 2 today, my lord. The writ petition.
Huh?
The writ petition is listed at court number 2,
So,
my lord. Just to bring my lord, sir.
yes, give the date.
4th of August.
4th of August.
No problem.
4th of August.
My lord. Obliged.
Then in that case, 4 weeks.
Obliged.
Number 4 and 5.
Wait, please, Lordship.
Yes.
My lord, we have filed this IA. My lord, the matter relates to award of a contract. The writ petition was allowed in our favor by the learned single judge.
Yes.
Against which, my lord, the writ appeal has been preferred. Before troubling your lordships with the merits of the case, if your lordships would kindly take the IA, my lord. 152. Now the appellant has sworn an affidavit, my lord, where he says neither he has signed the wakalat number nor he has filed the writ appeal. Page 15 of the IA, 152 of 25.
15, page 15.
Yes.
Yes. Yes.
I, Sri so-and-so, Sering, son of so-and-so, resident of Dirang, do hereby affirm that I have not signed the wakalatnama and I have not filed the writ appeal number so-and-so before the Honorable High Court. I further do not want to pursue the writ appeal number so-and-so. They have filed an affidavit, my lord, to this. They are saying that this is not identified before by the not deponent. In fact, my lord, he should have signed on the left-hand side, so he has signed on the right-hand side. And my lord, they have also filed an affidavit in the IA where they have brought out few facts regarding completion of the work. In fact, my lord, this new executive engineer, he joined on 12th, whereas that certificate which has been given annexed to the affidavit, that is signed on 4th. Affidavit on court, if your lordship would kindly come to page 31 of the IA, my lord.
31.
Yes. As it were. Even like a last
Yes.
Now, just to frustrate the my lord proceeding, they are trying to say this is certified that 14-kilometer formation cutting of the road from Crema to so-and-so has been completed by Tenzing Construction. At present, they have completed 74% of the work. It is also come to our notice that they have already given advance payment, etc. Now, kindly see, my lord, this is given by East Kameng district. This is not in East Kameng, my lord. This is in East Kameng. Now, my lord, this gentleman who signed the certificate on 4th, he in fact, my lord, took over charge only on, my lord, 12th. You can just have this, my lord. He has been recently transferred to this division, my lord. He joined on 12th. For the Honorable Court.
12/6.
Yes. Kindly see, my lord.
Certificate is of
He joined on 12th and the certificate is of 4th.
4th June.
Yes. Just to frustrate, my lord, our effort, my lord, they're trying to show that we have completed 74%. And even on merits, my lord, it's a very good case. That's why the learned single judge allowed the writ appeal. Sorry, writ petition.
So this writ petitioner,
Yes.
what is this affidavit?
Yes.
Yes, which for the Mr. Dimozumde is appearing online.
I'm appearing online.
Yes.
My lord, very unfortunate case, my lord. This IA filed, my lord, now for vacating the interim order, peculiarly takes the ground that the appellant, which is a farm, its proprietor has now filed an affidavit. My lord, apparently this IA has been filed because of certain subsequent event. My lord, I have been instructed to argue only on the basis of the facts narrated in the affidavit in opposition and not all those subsequent events based on which this entire episode has been now going on. A bare reading of the IA will find that the only ground on the basis of which this interim order is sought to be prayed for vacation of the interim order says that I have not filed the, I have not signed the Wakalatnama and I have not filed the writ appeal. Again, he says, I do not want to pursue the writ appeal. If you have not filed the affidavit, where is the question of not pursuing the writ appeal? Anyway, my lord, I am not on that. What I am on is, my lord, before I make any submissions on this, my lord, I'll just point out one thing, my lord. In this IA, the applicant doesn't say that he is not aware of the writ petition, that he has not executed a power of attorney based on which the power of attorney holder has filed an affidavit in the writ proceeding, contested the writ petition before the learned single judge, and ultimately when the order was passed, we have made a specific plea in the my lord affidavit in opposition to this IA that there was a discussion jointly. I'll go to that relevant paragraph, my lord, but he doesn't say that I am not aware of the writ appeal filed. I am not aware of the interim order passed in the writ appeal, and it is only after 14-15 days after the interim order was passed, this IA has been filed, my lord. You know, the lordship knows, my lord, what goes on there, my lord, in tender matters. My lord, regarding the
No, we don't know anything.
My lord. My lord, regarding
We
no,
don't
my
know
lord, about
anything.
the no, my lord, about the execution of work by persons.
We know
on the
what
basis of
is
power of
placed.
attorney.
We know, sir. We know what is placed before us. We don't know.
My lord,
Other than we don't.
I'm saying that, my lord. Your lordship is aware that in many cases, tender matters, my lord, execution is done by some other firm on the basis of a power of attorney, which has been going on here. Now, here is a case, my lord, the whole reliance is placed on a
Sir,
document.
this is, of course, this is technical thing, but at the same time, it's very serious. When the proprietor has not filed Wakalatnama and has not filed
my lord, I'm coming to
where
that,
is your who has filed this? Who has filed the writ petition?
Writ petition is filed by the present
Who has signed
applicant.
who has signed the Wakalatnama?
In the writ
I
petition,
mean,
my
who
lord.
has signed the affidavit?
In the writ petition, my lord.
Yes.
In the writ petition, my lord, the power of attorney holder, one Mr. Pao, has filed the affidavit. The proprietor never contested, never objected. Based on that affidavit, he engaged his counsel. His counsel appeared before the learned single judge,
No,
argued
if
the
the
case.
proprietor has not authorized you,
Proprietor has authorized, my lord, by a power of attorney, my lord. Proprietor has authorized a person by executing a power of attorney to, my lord, look after the case, look after the work, and represent him before the court proceedings in any sort of litigation. And there is no dispute about the matter. We have taken specifically in the counter. Now, my lord, regarding the acceptability and reliability of this affidavit, my lord, I will argue before your lordship, my lord, if this affidavit has to be accepted, lordship will have to see that under the Notaries Act and the rules, my lord, they have to maintain a register. He has taken specifically that he has never gone to that notary, my lord. It's a totally fabricated document. My lord, lordship, may kindly take up my affidavit in opposition, my lord. Just 2 paragraphs, we have mentioned everything, my lord. Lordship, may kindly take up the affidavit in opposition, my lord. Well, paragraph 4 onwards, I'll read 2-3 paragraphs, my lord. This will make the entire picture clear, my lord. at page 18, my lord. That the deponent states that after the writ petition filed by the applicant was allowed by the learned single judge, considering the fact that pursuant to the letter of intent, the work order issued in favor of the opposite party, about 65%.
No,
My lord.
no, where you are reading?
My lord, I am reading page 18 of my affidavit.
Page
18, my lord,
18.
of my 18, my lord.
And this is an affidavit on behalf of Lobsang Singh.
Yes, my lord. He is the person. He is the person. He is the proprietor, my lord.
Of
That is
what?
why, my lord, proprietor has filed this affidavit in opposition. This is the stand taken by the proprietor.
Tenzing,
My lord.
proprietor of Tenzing Construction.
My lord.
Then how can he file an affidavit? Why this affidavit again? Notarized.
That is what I am saying, my lord. That is what I am saying. That is what I am saying, my lord. Lordship, which one lordship will believe? Paragraph 4, my lord, I am reading. The deponent states that after the writ petition filed by the applicant was allowed by the learned single judge, considering the fact that pursuant to the letter of intent and the work order issued in favor of opposite party, about 65% progress was already made in the execution of the work, and the work of formation cutting was almost over. And he, I'm reading from paragraph 4, my lord.
No, just wait.
My
State, please.
Opposition respondent number 5. Respondent number 5 or affidavit in opposition is message. Respondent number 5 or affidavit in opposition.
Sir, let us resolve this issue.
Yes. No,
There's
but
something wrong.
my lord, what is very serious
Yes.
is,
Yes.
what is very serious is, he authorized Mr. X to represent before the learned single judge. My lord, it's not a firm, it's a proprietorship. In a proprietorship, my lord, the owner and proprietorship are one and the same. Now, before the learned single judge, he neither files a wakalatnama, neither he swears the affidavit. It is that person whom he authorized, and that is not, my lord, notarized. That is just an authority letter. Can he? Number one. Secondly, my lord, in writ appeal, the wakalatnama is not by the proprietor. Now, all of a sudden, the affidavit is by the proprietor. All throughout, my lord, he has chosen somebody else to represent him. And now why he has chosen to represent himself? He owes an answer to that. Where is that answer? It's a very serious matter, my lord. That means somebody else is abusing the process of law on behalf of somebody.
May I make my submissions, my lord?
Yes, no.
Madam.
Otherwise, so far as the appeal is concerned,
My lord.
we're of the view that it should be finally heard, maybe next week.
Yes.
After a week.
Yes,
Instead
my
of,
lord, yes.
I mean, considering the interment. But
Yes,
so far
madam.
as the conduct
My lord.
of this, who has
Appellant.
filed this affidavit, appellant.
Appellant.
Yes.
We'll
Yes.
direct him to file an affidavit.
Another
Particularly
affidavit.
with regard to his, the affidavit sworn, notarized, that he has not filed the wakalat, signed the wakalat and has not filed any writ appeal.
And also, my lord, why he has chosen all of a sudden for the first time in now to come and swear an affidavit.
Yes.
And also we never felt the necessity.
So who is
My lord,
what
so far
he
as,
wants
my
to
lord,
do?
may I make one submission? Before the
Yes.
learned single judge, the proprietor was represented by the constituted attorney. Where is the
No,
difficulty, my lord?
not attorney, my lord. How can my
Yes,
learned
my lord,
friend
yes,
describe
we
him
have
as
a power of
attorney?
attorney, my
Please
lord.
come to page 431. You are not attorney. You have just authorized him. What do you
No,
mean
no,
by
no, my lord,
attorney?
my lord, there is a
Please
power
come
of
to
attorney,
page
my lord.
431.
My lord, if your lordship desires
Letter
to
of
file an
authorization
affidavit,
is not attorney,
my lord,
okay?
if your lordship
Letter of
desires,
authorization. I,
It's okay.
Lobsang
My lord.
Clearing.
We'll consider
Yes.
including that in the appeal. So far as this IA is concerned, I
My
mean,
lord.
which will be listed along with this writ appeal.
Hmm.
We'll direct this proprietor,
my
My
lord,
lord,
Mr. Lobsang Singh, to file an affidavit with regard to the affidavit notarized by him filed by him, stating that he has not signed the Wakalatnama and has not filed the writ appeal 22.
My lord, your lordship said-
And thereafter,
My lord,
filing an affidavit in opposition to the IA.
my
Uh,
my lord,
My
my
lord,
lord,
there's one more thing, my lord. This,
by next date.
my lord, the IA is basically for vacating the stay order.
Yes.
But even on merit, my lord, if your lordship would kindly permit me 5 minutes time, my lord,
Sir, we'll hear it on
together.
together.
And till then,
We'll not dispose it of, we'll not consider that.
till then, my lord, they will maintain status quo, my lord. No far, because this is rainy season,
my lord,
nobody
that
is
will
going to
amount to
walk.
allowing the IA.
No, no, there's
itself.
nothing like allowing. My lord, this order has,
Sir, we'll see, we'll take it up. If it's not possible to dispose of the writ appeal after a week,
yes,
we'll consider it.
yes, lots
We'd
will
like to
observe.
first-
Yes,
we'd like to know
yes,
that.
ma'am. Yes.
In IA, huh? Heard Mr. Ken Chaudhary, learned senior counsel, assisted by RM
Deka.
learned counsel for the applicant.
And Mr. Pritam is also there. my lord.
And Mr. Pritapa, you mentioned, and for applicant of the respondent. Respondent number 1 in the writ appeal.
My
Respondent
lord.
number 1. And also had Mr. D. Majumdar, learned senior counsel, assisted by C. Bagan, learned counsel for appellant, opposite party appellant. And considering the subject matter which pertains to construction of road, comma,
Let us keep see.
we deem it appropriate that and we're of the view that the writ appeal be taken up for final disposal. Mr. Has agreed to be accordingly list this matter after.
Could it be Tuesday next, my lord?
uh,
Tuesday next.
I mean,
After the
Tuesday,
week.
let it, my lord, let it be 26th. So, 26th, my lord, Tuesday, my lord, a lot of matters are there in Guwahati.
26.
26th, my lord.
After a week, on 26, huh? 06/20/25.
My lord.
Next paragraph. Considering that the proprietor of the appellant has submitted an affidavit stating that he has not proprietor, huh? Namely of the appellant, namely Sri Lobsang Sri, submitted an affidavit as notarized, stating that he has not signed a Wakalatnama and has not filed the writ appeal number 22 of 2025.
My lord, that affidavit he's not admitting, lordship will only
On
he's saying it's a fabricated document.
on 10/06/2025, thereafter, and thereafter, filing the thereafter has filed an affidavit in opposition to the IA 152, IA 152 of 2025, comma, while taking serious view of the matter, comma, Sri Lobsang Sri, proprietor of the appellate, namely Tenzing so and so, shall file and they shall make his stand clear, make his stand.
Clear, my lord, yes.
No, will not say. Shall file an affidavit. Explaining the explaining his conduct in the
Milord,
proceedings.
Lordship will also put one thing in the order that they have completed 74% work. They're relying on a certificate dated 4th, whereas that person joined the division on 12th. That aspect may also be pointed out, Milord.
Oh.
Because it is the same
Sir,
appellant who has
that we'll consider on that day. We said,
Hmm.
we'll make it clear that,
Yeah.
that's why we are fixing it. We'll say, in case if the writ petition, it is also observed that in case the writ appeal is not disposed of on the next date fixed, the IA 152 AP 2025 shall be taken up. Consider then. Taken up and considered for disposal.
But only one submission I'll make. So far as the affidavit relied on by the applicant is concerned, my lord, the affidavit in opposition filed by the proprietor
We'll see.
No, my
Because
lord, he has not-
it has been notarized, the affidavit where he
We
said
are-
that, where,
My lord, only one
where-
submission,
where-
only one.
he has
My lord, only one submission
not
lordship
filed the
kindly permit.
affidavit. We'll see that there.
My lord, only one submission lordship kindly make, just one submission. That the affidavit they are relying with,
Yes.
the affidavit in opposition filed already says that it is a fabricated document. He is not admitting. My lordship has put it in such a way as if I am admitting that I have sworn an affidavit before the notary. I have not admitted that, my lord.
We'll see.
No,
There
my
may
lordship-
be
My lord,
consequences.
My lord, my submission is that your lordship has put it in such a way as if I am admitting that I have sworn
I
that
am not
affidavit.
expressing anything now. We have not decided.
Mhm.
It may rebound also,
Mhm.
right? It may rebound also. We'll see.
My lord,
Yes.
I am only saying that we have said it is a fabricated
We
document.
are just
Lordship-
directing on, by looking at the conduct,
My lord.
we express our seriousness. I mean, we express there's a displeasure, and accordingly, giving you an opportunity
To
to
clarify.
file an affidavit.
That's
all.
Deep.
To the lordship. So my brother, it may be taken up at least just a matter, lordship.
Huh?
This may be taken up today.
It's the promotion matter.
Promotion matter already DPC is going to be considered without us, lordship, without considering us. Therefore,
Item 7.
item 7.
Okay, we'll see.
Obligatory.
Measurement. I beg to measurement item 20, my lord.
20.
My lord.
Yes.
Praying the listing of matter after 2 weeks, my lord.
Why?
My lord,
What is there?
I have some,
What is there?
I have some medical emergency, my lord.
You may have, but what is the matter? Nothing. We have already observed. Next week? After 10 days.
2 weeks, my lord.
After 10 days.
2 weeks, my lord.
Why? Anyway, we have already made an observation last occasion.
Similar,
For sake.
next occasion, my lord, I will try to satisfy my lord. I have case, my lord.
So when?
Next occasion. After
Not,
2 weeks,
not
my lord.
before this bench.
No, it's not that, my lord. I'll, in any event, my lord, I'll try to satisfy my lord.
On the prayer of Mr. L. Perme. What medical emergency? Your own
No, my
medical
lord,
emergency.
family member, my lord.
Yeah. Mr. El Perme, learned counsel, submits that he has some medical emergency. Therefore, prays for missing adjournment of this matter after 2 weeks. Praise the Lord, at least after 2 weeks. Item 20.
Interim, my lord, is taken.
Interim on the personal, let's say, continue.
Hello, my lord.
Why? You want to file affidavit?
My lord, they have already filed, my lord. Let it be after 4 weeks,
Without,
my lord.
without opportunity.
Yes, yes, my lord, that is.
It's already recorded. This
Even
court
the-
has already recorded on the period of the record.
Yes,
Have,
ma'am.
have you filed the affidavit? Can you show that he was given an opportunity of hearing? Why it should be adjourned? You are seeking adjournment. Why it should be? Okay, Mr. MSK Wangmo, London State Council submitted. And they engaged interested council, State Council MSG at London Edition. Senior government has some personal difficulty. Therefore, press for listing of the matter. After 2 weeks.
Let
Prayer
it
not
be
being-
after
prayer-
3 weeks, my lord.
3
In
weeks,
time,
yeah.
if necessary, we will file our adjournment.
Prayer below. Prayer not being objected to by Mr. Disoki, Land Council for the petition. Prayer is allowed, list after, same is allowed, list after the 3 weeks. Huh?
So, my lord, there's an interim order, my lord.
Interim order passed, and this will continue.
All right.
Your Lordship, I would like to mention item number 18 and 19, Your Lordship.
8 and
18 and 19.
18 and 19, why?
Your Lordship, in this matter, earlier Standing Council, UD Department used to appear, Lordship. Now Government Council will appear. Some more time may be given for us, Your Lordship, to
Yes,
go to the.
no objection. No objection. Because your senior has, Madam mentioned, the senior has last occasion submitted that there's urgency in the matter. That's the reason that's why this has been made listed.
Yes, Lordship.
Yes, consented, Lordship, we have taken consent.
MS Arbasar, London Council, London State Council submits that. On behalf of the state respondents, earlier London Council, London State Council was engaged. However, now however, the London government advocate has been interested in the matter. Now, therefore, 6 more time, 6 for adjournment of the matter is the prayer not being objected by London Council for the petitioner. My same is allowed. List after 3 weeks.
3 weeks,
3
Your
weeks.
Lordship. Problem.
May Lordship.
Ah.
Lordship, we dance on behalf of Senior Standing Council Tavatagum. Due to personal difficulties, he is out
On
of
the
state.
prayer of so and so, adjourn after 2 weeks.
Lordship,
I am for the petitioner. Interim may be continued. my lord.
Interim order to continue. You record his name, El Kurdo. Prayer not being objected, huh? For petitioner. Please. Next.
Lordship, item number 3.
Ah.
Here, your Lordship, the other is directed to list this matter.
Let us see. Then why has been listed here? Item 3.
Yes, sir.
No, there's no order.
Your Lordship, there is one matter CRP 7. One matter is there CRP 7. In that case, Your Lordship is directed to list the matter in other bench. Both are connected. This
Both are
one-
connected.
Yes, both this one.
Okay. In that case, as pointed out by London Council, Mr. London Council for the petitioner, Mr.
M. Kambo.
Uncom. This court has recused from taking up the connected matters in respect of the petition. Mr. In view of above, this matter before any other approved events without me. Yeah. Okay.
Please, my lord.
Yes.
My lord, beg to mention item number 18 and 19 on behalf of senior counsel, Mr. P.K.
Already mentioned.
Oh.
Already adjourned.
Oblige, my lord.
May it please your lordship. My lord, we are praying for quashing of this proceeding, my lord, on among several grounds. The first ground is, my lord, there is violation of section 233 and 235 of the BNSS. Now, if your lordship would kindly,
Sir, why read petition?
my lord,
Why don't you?
no, my
approach
lord,
the inherent
whether
power of-
220 or 482, both can be filed, my lord. We have filed 226 for the simple reason, my lord, there is no jurisdiction. That I'll satisfy first. Now, if your lordship would kindly come to the complaint in the second volume. In fact, they have not given a lot. We have also application.
772.
Yes, page 772. This is the complaint. Now, if your lordship would kindly come to me, lord, page number 778, where they have made a wrong, I would say false, but it's a separation, my lord. Para 17. That by summons dated 4/6/25, documents related to investigation were sought. The company submitted a letter dated 8/6/25 mentioning that company should need of 2 weeks for submission of the documents, roughly asking for time up to 22/6/25. It is also noteworthy that last date of completion of this investigation and issuance of so-called notice on 30/6/25 by virtue of section 74 of the GST Act 2017. And asking for such reasonable time is deliberate attempt of the accused to delay the proceedings of the complainant to cause time barring of any demand in respect of GST evasion in the financial year 2018-19. And that it is a fact that on 8/6/25, we prayed for time. Now, yes. Now, my lord will kindly come to page number 769. This was a mail given by us on 10/6/25, my lord, page 769. This was a mail given by us. Kindly see, please find the attachment on the above mentioned subject. That is to 8/6/25, our application. Now please come to 770.
Yes.
This is in relation to summons dated 5/6/2025 and your letter dated 8/6/25, which is referred in para 17, my lord, wherein it was requested for 2 weeks time for submission of documents and for personal appearance as sought by summons dated so-and-so. Considering the said request and approaching deadline for issuance of show cause notice for the financial year, the day of appearance has been fixed on 19/6. So he has extended the time, my lord. Now this is suppressed in para 17. Now, my lord will kindly come to page number 779 for 780 for a moment, my lord. 780. This is the affidavit annexed to the complaint filed before the trial court. Please see para 2, my lord. That the statement made in paragraph 1 to 7 and 18 of the criminal complaint are true to the best of my knowledge, and those made in paragraph 8 to 17 are true to my information derived from record. Now, record is, my lord, the page 669 which we have shown. In fact, this complaint was filed on 10/6, my lord.
Same day.
Yes. and time was given. My lord will kindly take note of few dates, my lord. And impression is sought as we have not cooperated. We have appeared on 21/4/25, 22/4/25, 28/4/25, 9/5/25, and 16/5/25. In fact, my lord, we waited up to 11:30 at night also in the office. So, my lord, the entire, the complaint is based on falsehood. Now, my lord, kindly see this complaint is under section 208 of the BNS. Please have BNS for a moment, my lord. Asana kitabkhon. 208, my lord. Non-attendance to an order from public servant. Whoever being legally bound to attend in any person or by an agent at a certain place and time, in obedience to a summons, notice, order, or proclamation proceeding from any public servant, legally competent as such public servant, to issue the same intentionally or to attend. I never omitted to attend, intentionally omitted to attend, my lord, to attract section 208. I appeared on 5/6 date. On 8th application, give us 2 weeks time, and time was granted. And that aspect has been suppressed in paragraph 17 of the complaint. My lord, the omission must be intentional. Where is the intentional, my lord? Para 7, the petition, we have explained how to time we have appeared. Now, my lord, though we are a distributor of state of Arunachal, are being sold in the state of Punjab and Maharashtra. Therefore, the jurisdictional proper officer, it is the commissioner of that place, not the one sitting in Arunachal Pradesh at Itanagar. I'll show that. So, my lord, prima facie, my lord, there is no basic ingredient to attract to from, my lord. This complaint is an abuse of the process of law. Now, jurisdiction point, my lord. If your lordships would kindly have, my lord, the GST Act for a moment, my lord. Now, before that, Lord, kindly take BNS for BNS. BNS, not SS. BNSS, I'm sorry, 223. BNSS. $223 million. Magistrate shall be and shall be signed by the complainant and witnesses and also by the magistrate. Now the proviso is important, my lord. Provided that no cognizance of an offense shall be taken by the magistrate without giving the accused an opportunity of being heard. So, my lord, the statutory mandate is before taking cognizance, the magistrate must give the accused an opportunity of hearing, my lord. Then, my lord, will kindly come to 225. Another provision. Because the petitioners before your lordships, my lord, they reside outside the jurisdiction of the court at Itanagar. Kindly see postponement of the issue of process. So any my lord, 2. Yes.
It's okay. No, continue.
Yes, I'm sorry. Yes. Now, my lord, 225 is a provision.
It's okay.
Yes. Now, my lord will kindly come to the 2 orders.
Yes.
At page number at page number 804.
804.
Just to show, my lord, that there was no compliance of 223. My lord.
Yes.
Case record put up on the strength of criminal complaint, that is the one which I have placed, my lord. Hard Sri so-and-so is complainant. Learned counsel submits that in for dismissal of Arunachal Pradesh. However, the accused persons functioning under the name of Future Gaming and Hotel Services Private Limited has failed to file GST return for the last 5 years, beginning from 2020, in spite of conducting several businesses under authorization. He further submits that several notices were issued as per section 169 of the GST Act by way of a registered post through email. As such, his accused persons have failed to appear. He submits that as per mandate, time limited GST return is 4.5 years. Order is reserved for next day. So on that date, my lord, 12, the magistrate did not pass any order. Now he passes the order on 16/6 at next page. Today, the case is fixed for Skipai is present for complainant. Hard learned counsel on 12/6 issue notice to the accused persons. So my lord, he issues notice. Now please come to the summon at page 807. Same magistrate. So he passes an order of issuance of notice. Now kindly see, my lord, the learned magistrate passes the summon. Whereas complainant has filed a case under section 45, 225 before court under section 210A and 223 of BNSS, praying for issuance of arrest warrant under section so-and-so for committed offense committed under section 208. Instant court has taken cognizance of offense under section 208. Where has he taken cognizance, my lord, on 16th? So before taking cognizance under the proviso, he has to give me a hearing. That hearing has not taken place. So I cannot file a review, my lord. There is no scope of review by the criminal court. Am I clear, my lord?
Yes.
Number one, the complaint based on incomplete facts. Let us not use the expression suppression or incorrect. Number two, my lord, the magistrate commits error in his taking cognizance without giving me a hearing. And number three, my lord, now I'll come to your lordship's query. Why 226? Why not, my lord, a 482? Though there is no bar. Now, my lord, if your lordship would kindly take the GST Act, Goods and Services Tax Act, my lord, 2-3 provisions.
72.
Yes, my lord.
Next one annexer, where it's clearly stated that if there is investigating going before the CGST, then that person has been summoned thrice. Then subsequently, if that person
that
doesn't-
is
yes,
earlier.
My lord,
Yeah.
let my learned
No.
friend satisfy that they have got jurisdiction. That was what I was trying to show from the GST Act. My lord, it works on a, my lord, we have paid 31,000 crore tax. Please come to para 11 of the writ petition, my lord. But they are saying we are not paying tax. You don't understand
we
the
are,
law.
Lordship, we are into 2018 and 19 only.
Yes, yes.
Not
Please
about
come to
remaining.
paragraph 11, my lord.
So in that
Paragraph
regard,
11, page number 17. Para 11, page 17. That based on the reverse charge mechanism since inceptions of CGST Act and in connection with the state organized lottery of various states, of which so that is the petitioner company is a distributor, has paid GST of around 31,271.47 crore. My lord, let my learned friend show that the summon which has been issued by the Itanagar office they have any jurisdiction. My lord, the proper officer is defined in the act. Who is a proper officer?
now I will
Who is assigned to, no, I have not completed. Please let me complete. If your lordship would kindly permit me, my lord, just to, or if your lordship is inclined to pass that order, I will not argue pardon. Or if your lordship just to show why they have no jurisdiction, I am prepared to do that, my lord. If your lordship would kindly take the GST Act, my lord.
Yes.
If your lordship would kindly come to section 70. I think it is page 64, my lord.
Yes.
Power evidence and produce documents. Proper officer, the proper officer under this act shall have power to issue summons to any person whose attendance he considers necessary, either to give evidence or produce a document or any other thing in any inquiry in the same manner as provided in the case of civil code under the provisions of Code of Civil Procedure. My lord, supposing a civil court issues a summons to me, I don't appear. Can civil court direct, my lord, initiation of a complaint? My lord, this offense 208, this is, my lord, non-cognizable and bailable. By issuing warrant, my lord, they are trying to make it non-bailable and cognizable. Now, my lord will kindly come to 72. Officers to assist proper officer. All officers of police, railways, customs, and those engaged in collection of land revenue, including village officers, etc., shall assist the proper officer in implementation of this act. Now, what is a proper officer? It is defined in section 2, my lord. 291. That is, yes. 291, my lord.
Yes.
Proper officer in relation to any function to be performed under this act means the commissioner or the officer of the central tax, which is assigned that function by commissioner in the board. So every officer of, my lord, GST is not a proper officer. Proper officer is that officer who is assigned to do a particular task. Now, my lord, the allegation is that we have not registered in Arunachal Pradesh. Now, let us see, my lord. If your lordships would kindly come to, my lord. Yes. CGST Act, section 24. Section 24(3), my lord. Compulsory registration in certain cases. Notwithstanding anything contained in subsection 1 of section 22, the following categories of persons shall be required to be registered under this act. Persons who are required to pay tax under reverse charge. We are required to do and we have done. Then 25. Procedure for registration. Every person who is liable to be registered under section 22 or 24 shall apply for registration in every such state or union territory in which he is so liable within 30 days from the date on which he becomes liable to registration in such manner and subject to such condition as may be prescribed. So it says, my lord, state or union territory in which he is liable. Now, where I am liable, I'll show from the, my lord, integrated CGST Act. If your lordships will now kindly come to section 7 and 10 of the IGST Act, which is at page number 136, I think, of this book, my lord. Page 136.
Yes.
Interstate supply. subject to the provisions of section 10, supply of goods where the location of the supplier and the place of supply are in, my lord, are in different states, two different union territories, or a state and union territory, shall be treated as a supply of goods in course of interstate trade and commerce. Then my lord will kindly come to section 10. Where is the, my lord, taxable event? Place of supply of goods other than supply of goods imported into or exported. The place of supply of goods other than imported from India shall be as under. A, where supply involves movement of goods, whether by supplier or recipient, or by any other person, the place of supply of such goods shall be the location of the goods at the time at which movement of the good terminates for delivery to the recipient. My lord, these tickets of Arunachal lottery we are not selling in Arunachal. We are selling in, my lord, Maharashtra and Punjab. And to that there is a notification. And that notification is at page number, my lord, 105. First, please come to 105, my lord, of the writ petition. Notification number 4 of 2017. In exercise of the power conferred by subsection 3 of section 9 of the CGST Act 2020, the central government on recommendation of the council hereby specifies supply of goods, the description of which is specified in column 3 of the table below and falling under tariff item, subheading, heading or chapter as the case may be, as specified in the corresponding entry in column corresponding entry in column number 4 in respect of tax, which tax shall be on reverse charge basis by recipient of the interstate supply. Now, my lord, will kindly come to my writ petition to amendments, my lord. Please come to paragraph 3. Paragraph 4, my lord, at page 7. That under an agreement dated 27/7/15, that is the petitioner company was appointed as distributor of lotteries organized by the state of Andhra Pradesh. GST is destined for as FGHSL does not sell any lottery within the state of Arunachal Pradesh. Or carry so registered of orders. And Arunachal Pradesh lotteries are distributed by petitioner in the states of Maharashtra and Punjab. That the petitioner begs to state lotteries attract 28% GST, which is paid by the distributor under reverse charge mechanism. The relation I have already 6.4. Case number 4 dated 28/6/27. It should be 17. Provides for reverse charge. So far as the state organized lotteries are concerned, these same are provided as under. In exercise of the power conferred by so and so, so and so, so and so, then created in the other by reading the main notification. Then my lord will kindly come to page 12, para 6.5. Page 12, para 6.5. Therefore, the position that emerges is that the distributor, selling agent in case of sale of selling lotteries in other state B and C is required to pay IGST under reverse charge mechanism in the state of B and C. Once lottery ticket suffers CGST at stage of supply between the state government and distributor, further supply down the chain is exempted from payment of GST. Now, this is, my lord, in terms of notification at page 108. Please come to, my lord, page 108. In exercise of the power conferred by subsection 1 of section 11 of the Central Goods Services Tax, the central government being satisfied that it is necessary in public interest so to do on the recommendation of the Central Council, hereby exempts intrastate supply of goods, the description of which is in schedule column 3. Now column 3, serial number 149 at page 115. At 115, serial 149. Supply of lottery by any person other than state government, union territory, local authority subject to condition that supply of such lottery has suffered appropriate central tax, state tax, union territory or integrated tax as the case may be, when supplied by state government, union territory so and so as the case may be, to the lottery distributor selling agent appointed by so and so as the case may be. That is, in this situation, my lord, the supply chain down the line is exempted. Now kindly see, my lord, I am not required to be registered. I am not required to be registered. So where is the requirement of paying? My lord, in every response which we have made, notices issued by the GST authority, we have questioned their authority. For example, if your lordship should kindly come to page number 352.
Yes.
Now earlier some summons were issued. My lord will kindly come to page number 353. Para 2. With regard to the summons dated 35/25, I request that my personal appearance may be kindly be exempted as I am suffering from viral fever, etc., etc. Then para 3. Without prejudice to our rights and remedies, we submit that we may kindly be granted 3 weeks' time to provide the requisite information and document. At the same time, in addition to the jurisdictional issue raised by us earlier, we found that we are the one I read at page 108. You may not have the territorial jurisdiction to issue summons. More particularly, I invite your kind attention to the table 2 of the said notification, territorial jurisdiction principal commissioner, so and so, so and so. Every notice, when we responded, my lord, though we have answered, we have also raised the jurisdictional issue. Now, kindly see, my lord, why they require my personal appearance, and that is by represented by lawyer also. Now they are insisting on. So therefore, my lord, here is a case. First, I am not required to be registered. Therefore, I have no obligation to pay GST here, my lord. I am paying in this state. As per my registration, I am already paying. And until that, I have paid 31,000 crore. Ever since, my lord, GST has been introduced. Secondly, my lord, you are alleging me for violation of section 208. Section 208 can be attracted when there is an intentional omission. Where have I omitted? I have appeared on several dates. Even last time on 8/6 when I applied, you gave us time till 19/6, but you have suppressed that fact in the complaint. You have made a wrong statement in the complaint. And on the same day, you gave us time, you also filed the complaint. Then, my lord, there was a hearing before the magistrate at their instance where I was not heard. Now, lordship knows under 233, before even issuing or taking cognizance, I must be heard. Whereas the order does not say anything, but the someone says that cognizance has been taken. Now, on what basis they are proceeding? So therefore, my lord, in the petition, we have clearly brought out, it's a clear case of abuse of authority, my lord. Kindly see, my lord, my formal articulations, my lord, at page C of the petition. A, my lord, lack of territorial jurisdiction. B, respondent is not the proper officer. Violation of departmental instruction. Malafide action and suppression of facts. Abuse of the process of law. Impugn summons is contrary to order dated so and so. Complaint does not disclose ingredient of section 208. Complaint and the proceedings arising therefrom are an abuse of the process of law. It's an absolutely fit case, my lord, where the case falls within these broad headlines. You are saying I have not paid tax. Why should I pay tax here? Please read the act properly. Then you will get to know whether you have authority or not.
What is this? The orders that is 12/6/20?
My lord.
12/6 and 16/6.
Yes, orders.
Yes.
Yes, that orders are there, my lord. 12/6 order is at page 804.
804.
Yes. I'm reading the operative portion, my lord. The Learned Council submits accused persons were authorized by the government of Arunachal Pradesh for distribution of lottery tickets on behalf of the government of Arunachal Pradesh. However, accused persons functioning under the name of Future Gaming and Hotel Services has failed to file GST return for the last 5 years, beginning from 2020, in spite of conducting several businesses under the authorization. So, my lord, this is absolutely wrong.
Yeah, basically against these two orders. Also.
Yes,
By
these two orders and the
Judicial
summon.
Magistrate was clerk.
And summon. And summon, my lord, why personal appearance? One should appear either personally or through lawyer. That's the form. This shows the malafide, my lord. And my lord, the director of the company, he has suffered a brain stroke, my lord. He is lying on bed, retired from the business. In any case, he cannot appear under any circumstance. He is in hospital. Hardly, my lord, 5 days in hospital, 5 days he is at home.
Lordship,
Yes.
may I?
Yes,
Please. Lordship need to clarify this. What's RCM? When RCM will be once applicable? So RCM is reverse charge mechanism, where if suppose usually it apply to anyone who.
It's okay, we understand. Why rush?
Yeah, Lordship.
Why
Okay,
rush?
now why
When
this is
you have
restricted?
granted them till 19, for 19.
Now that's why I will
Today.
answer that.
Why you have to? You
Okay.
answer that first, for the
One-
purpose of this.
page
What is
174.
RCM and what is this jurisdiction? Will those you notice?
Yeah,
Why it
notice-
should not be stayed? Just argue on that.
That's why this should not be a state. Page 174 of their petition.
Yes.
174, Roman 10.
Huh.
Roman 10.
Hmm.
They annex this annexer.
174.
4. Yeah.
Yes.
Why this criminal complaint is required?
Hmm.
May I? 174, Roman 10.
Yes.
Issuance of repeated summons without ensuring service of this summon must be avoided. Sometimes it may so happen that summoned person does not join investigation even after being repeatedly summoned. In such cases, after giving reasonable opportunity, generally 3 summons at reasonable intervals, a complaint should be filed with the jurisdictional magistrate. That's a jurisdictional magistrate, JMFC, UPA, alleging that the accused has committed offense under section 172 of Indian Penal Code, absconding to avoid service of summons or other proceeding, and or 174 of Indian Penal Code, non-attendance in obedience to an order from public servant. That's in BNSS. That's a 208. As inquiry under section 70 of CGST Act.
No, first you will have to show issuance of repeated summons. They are responding to your summons.
Lordship,
and you have granted
now-
a time to them.
Yes, now here, section 74 of CGST. Section 74 of CGST, clause 2 and clause 10. It clearly states that if any inquiry or demand to recover some amount from the SSC, that need to be demand need to be issued prior to 6 months of this, means 4 years, 6 months. And it should be issued within 5 years. And it should be recovered within 5 years. And this means SSC, that person has not paid the, filed the return from 2018 to 19. And we are into only 18 to 19. And they were supposed to file return in the year 2020. From then onwards, 2000 to 2005, 25, till that, they are not filed the return. And in that regard, this officer, they are doing the investigation. But it's a time-bound investigation. By the month of this month, 30 of this month, that time period will elapse as per the section 74, clause 9 and clause 10 of the CGST Act. Then what happened? Government cannot demand that tax from that person because that's a technical part. So they will get the benefit that they're not liable to pay that tax. So that's the reason after repeated summon, if they're not appearing and making different type of excuses. So that's the reason this.
No, you have granted yourself.
Page
You have granted-
771, my lord.
You
They
have
have suppressed
granted,
this
Lordship,
later.
that's why.
you have granted them.
Yes, in that regard.
And then you have, on the same day, you have filed the complaint.
Yes.
No, now,
Yeah.
it's a 3 repeated summon. Now that's the 4th summon. And as per the record,
But maybe
their
10
officer are
maybe-
liable to answer their superior
Yeah,
authority,
it's
Lordship.
10 summon or 15 summons.
Lordship, 3 summon. After 3 summon, this need to be filed. Because officer, whoever may be investigating officer, they are answerable
And
to
then
their
also
superior officer.
They are questioning your jurisdiction.
Yes.
Now here comes RCM. Since the lottery,
We'll examine it. No way out.
Lordship, since the lottery is being sold by the government of Arunachal Pradesh, and once government means sell something or anything, then we cannot tax, tax will not, GST will not levy to the government. But in that regard, Lordship may go through section 9, clause 5, where it's written that if someone is selling on behalf of government, then that person is liable to pay that RCN. Now here, as per the director of that lottery department, government of Arunachal Pradesh, as per their subscription and statement, what's going on? For example, if they had bought 10,000 tickets from the government of Arunachal Pradesh, what they are doing, they are just showing 2,000, and they're not paying for remaining 8,000 tickets RCN. So that's the issue over here. So in that regard, officer need all the document and data from the director. So that's the reason they need to appear before the officer just to confirm whether those documents are complied or not. And they're just trying to evade the tax, suppress the tax by stating that they registered in Maharashtra and
So
Punjab.
let us do one thing. We'll issue notice.
Milord, I'll
Yes,
just-
Lordship.
If,
Yes.
no,
We'll issue
no,
notice.
Milord, my
We'll-
learned
we'll-
friend is
we'll-
saying regarding unsold tickets, even for
Sir,
that also.
We'll examine it.
Yes,
Since he's saying that the time will be lapsed
Yes.
by
Yes.
13, let us do one thing. We'll stay these proceedings.
yes.
But then to continue the proceedings by them till whatever you want to make a
Yes.
reply.
No, ultimately,
them
if I,
appear, sir.
if I,
You-
Milord,
you-
if
you-
I
no,
lose,
no,
if
no.
I lose, they will be at liberty to proceed.
No, what I'm suggesting is you appear
Before,
23rd,
Ah.
before the commissioner,
yes, Lordship.
No, Milord.
whatever.
No, not personally. Why personally, my lord? Where from they got this? Let my
Lordship,
learned friend show the
No,
form.
we'll not say personally.
Yes.
Through the representative.
Representative,
or by
yes,
the
yes.
Council, whatever.
Lordship,
What you want to do,
Lordship,
by calling them what you want to do.
Lordship, it's very simple. They have all the
First
documents.
of all,
Yes.
you
And they are
want-
not giving those
what-
documents.
they will give whatever. If they don't give, you can pursue the
No.
remedy, whatever is there.
But
Yes.
if
So we'll fix the not for personal appearance. You continue the proceeding, you do your proceedings on particular date.
Yes,
Before the lapse of 30
Ah.
this month. By maybe 26, 27.
And my lord,
whatever.
we have given, if you will kindly permit me, Milord,
Yes.
please come to para 17 of the writ petition onwards. Each and every date what had happened, we have explained.
No, I've seen it. I've seen it. That's
Yes.
why. That's the reason.
We have given everything, my lord. We have got nothing else.
Yes, you are questioning the jurisdiction will examine it.
Yes.
And the authority of the, I mean, whether it's as per the law or not, will also examine that. So far as the
Jurisdiction-
magistrate summon is concerned and the taking cognizance and all this thing,
Yes.
will stay on this thing.
Lordship,
Yes.
But
magistrate,
then we'll direct the, you proceed with the proceedings, fixing a date before 38th.
Some representative will appear.
Lordship, here, it take around 8 or 9 days to issue show cause to raise the demand because it's a digital data. Where means all the document will be examined and later on that will be uploaded.
It's up to you, whatever you
That-
can.
that-
You cannot help it. On 12 or 10, you have granted time till 19. Today,
Yes.
suppose if they furnish it
That's
also,
why
if it
on-
takes 10
No,
or
why
12,
have they suppressed this
then
fact?
What will happen then?
We are not into that, means.
Why?
any-
Why? That
What
is
do you
the
want
main
to do? What
thing.
is your precedence?
We need only that person to appear and
what
submit
is
those
your-
documents,
what-
Lordship.
Huh?
Submit those documents which are
That's why,
required.
That's why.
Yes,
Will then, in that case, will direct the representative.
yes,
Let them
yes.
Submit the document.
With authorized letter, proper
Whatever,
authority. Because
authorized,
sometimes whatever,
representative, whatever.
anyone come down and they will say, I'm authorized, but it's very difficult to ask them the question. What are the document, where are the document, Lordship?
Anyway,
Authorized.
where is the demand notice?
My lord.
No,
No, there is no demand.
That's why.
only summons.
Yes,
Yes.
only someone.
Okay.
That close to order 12/6, 16/6 and this summer.
Okay.
Pays, my lord.
No, these commissioners or this GST, they have not issued any notice.
No,
Yeah,
based
it
on
should-
this notice,
someone-
only these orders have been, complaint has been filed.
Okay.
Lordship, someone
According
has,
to them, my lord, because we have not responded to the summons,
Hmm.
therefore they have filed the complaint under section 208.
Whereas you are responding to them.
Yes, my lord, we have appeared on so many days. Para 17 to 47, we have explained everything. We have submitted all documents. If they pretend not to understand, we can't help it, my lord.
Lordship, we are into document only,
Let us
nothing.
go do this way. Heard Mr. K.N. Chaudhary, learned Senior Counsel assisted by Mr. R.M. Lekha, learned counsel for the petitioners. Two
Petitioner,
petitioners.
two petitioner. And petitioner number 2, he is bedridden, my lord. He has suffered a brain stroke.
Will say authorized representative.
Yes.
Yes, with proper authority letter.
Will not
Yes,
all
yes.
this thing, will say authorized representative. Challenge made in this writ petition is to the against the filing of the complaint by the GST authority. Respondent number?
That single respondent.
Respondent GST authority. Being the CR number 45 of 2025. Before that, learn JMFC Papumpara district. And the orders dated 12/06/2025. 16/02/2025. And the summons that is 16/06/2025. Against the petitioners. This present writ petition has been filed. Questioning the jurisdiction of the, questioning the jurisdiction and authority of the respondents as well as the court of JMFC of the judicial magistrate first class on the ground that the proceedings.
And basically, we are questioning the jurisdiction of
No,
the
I've said-
authority, GST authority.
GST authority as well as the.
Yes.
You are saying that no.
No. Because based on this.
Next paragraph. Mr. K. Chaudhary. While referring to the various provisions of the GST, GST Act, IGST, as well as the BNS and BNSS 2023, submitted. The authority, GST authority doesn't have the jurisdiction as the petitioners. It's a company, petition company, although authorized distributor
Yeah, but we are selling it in Maharashtra and Punjab.
of the lottery, state lottery.
And we have got registration, GST and number of for that.
Is not selling a lottery. He's only selling a lottery in the state of Maharashtra and Punjab.
Punjab
and
With the
Maharashtra. Mila.
valid registration, GST registration.
Yes.
Mr.
And they are registered in Tamil Nadu.
And my lord, yes, we are registered at Tamil Nadu.
Yes.
Registered in Tamil Nadu. So you are paying the GST?
Yes, my lord, at page 6, we have given the chart, the number is there.
Okay.
Lordship, they are not paying
It's
the
okay,
state
it's in
government.
submission now.
Yes.
We're not accepting directly now,
Okay.
today. There were summoned by the GST authority is without jurisdiction, and as a sequel, the criminal complaint and the orders passed by the judicial magistrate
As well as the summon.
and the summons for refugees, after taking cognizance of the offense, at least the offense under BNS 208 of section 208 of BNS is absolutely without jurisdiction and not in accordance with the law. Issue notice returnable by make it 4
My
weeks.
lord, yes,
4
so
weeks.
let it be after the 21st.
Lordship,
No, no, we're providing, just wait, let's listen. Considering that the petitioners, although petitioner, the petitioner company is also a petitioner company, although is the authorized distributor of state lottery of Arunachal Pradesh. The selling is only in the state of
Maharashtra and
Maharashtra
Punjab.
and Punjab with the registration, GST registration in the state of Tamil
Yes.
Nadu. And the summons is by the GST authorities for the state of Arunachal Pradesh. And the complaint being CR 45 of 2025 filed by the GST authority based on the such summons, I'm inclined to stay the orders dated 12/6, then 16/6, and the summons dated 16/6 against was and issued against the petitioners. Accordingly, same shall remain suspended till the returnable date. However, considering the issue of GST, it is directed that the petitioners shall appear through their attend to the proceedings by the GST authority through their
Authorized representative.
On when?
23rd?
Not 23rd.
Yes.
23rd will be on the same date.
23rd.
Which yes,
It can be.
Make it 26,
If they are available, then they can come because short date, otherwise.
26.
26, 26. I think that will be balanced.
Yes.
It will be very difficult.
Deeply
for-
obliged.
Highly obliged, Lordship.
Deeply obliged. Okay, ma'am. Okay, ma'am.
May I please, Your Lordship?
Yes.
No, I pray for this item, my lord. Let this item be listed along with the connected writ petition, which is pending before this one. WPC number 0/2024.
What is the matter, sir?
Here, the petitioners are the extension officer
Hmm.
and the person junior to the petitioner.
Pleadings are complete.
Not complete here, in this case, my lord.
Huh?
But in the connected writ petition, they have filed affidavit.
Yes.
We have
No
not filed-
affidavit.
No
Who
affidavit.
has filed the additional affidavit?
Petitioner, we have filed, petitioner, my lord. So
I don't, affidavit is filed. 1, 2, 3. Is there any private respondents? No.
No, my lord.
Then affidavit has been filed.
Yes.
Have you received the additional? What is additional affidavit?
Additional
for?
affidavit only to bring the records of the appointment order of the petitioners, my lord.
It's okay then.
Yes, my lord.
Yes, they have filed the affidavit.
Yeah, my lord.
They've already filed. Pleadings come out, Mr. So-and-so,
A Boroman.
for the petitioners, and Mr. BP, Land Council for the land standing ones for respondents. Are the Rural Development Department for respondents, for all the respondents.
All the respondents.
Pleadings are complete. List this matter along with, as spread for.
WPC number 390.
List this matter along with.
WPC number 390
390
of
of
2024.
24. After
That may be given on
3 weeks.
25th of July. Any
After 3 weeks.
after 3 weeks, madam.
Published.
Developed.
No affidavit.
Some more time.
Yes. What is the matter?
Your Lordship,
Huh? What is the matter, sir? What is the matter, sir?
Your Lordship, this is about BRTF grip illegally occupying my land, Your Lordship.
Hmm? Mr. So-and-so, land management. On the prayer of MSK, Land State Council, for the 3 weeks time is granted for filing an affidavit. Hmm.
Pleadings are complete, my lord.
Will admit and list is for hearing.
I have no objections, my lord. This is my learned friend who is.
Where?
My lord, it is 65 days. It is 75.
I will read before your lordships.
30th of June.
Hmm?
75 certificate of the need. It's expiring on my lord.
What?
I don't think date which has been
Validity of the
challenged-
NIT is expiring on 30. That's what. it is.
No,
That's
that
been
will state. Your, this will not. Let us do it after that, after 2 weeks.
Maybe admitted and there are.
Will admit. And Mr. Deepan, Land Council for the petition, and Mr. BKC, Land Council. That is,
FCI, the tender
FCI.
cancellation is.
Huh?
Tender cancellation, my lord.
Of what?
Just a moment.
Road transport contract.
Yes, yes.
Okay.
Yeah.
Hmm. There's no, disruption of food supply.
No, I'm doing it on ad hoc now.
Acha. So obviously, you are not in a hurry. BKC Land Council. You are challenging the cancellation.
Yes, ma'am.
Okay.
Because the
Challenging cancellation and
initial.
also challenging the present NIT regular tender which has been floated by the FCI. That is 25.
Yes.
That.
So he's doing the.
That is in the
That is on ad hoc NIT.
Okay.
ad hoc NIT that I have
There was an NIT floated by the Food Corporation of India. He was the L1, but the price was higher side. Thereafter, we had cancelled that one and we had issued the ad hoc tender. He has applied and just being the L1, he was given the tender, my lord. Earlier, it was the price was 4250. Now in ad hoc, he has quoted 3990. So our cancellation of that NIT on the ground that it was in a higher side. Points 45, my lord, by because the petitioner himself has quoted the lower rate, my lord, 3990, my lord. So now after floating of the ad hoc tender, we have floated the regular tender. That ad hoc tender was for 3 months only. 3 months, which will be actionable for another 3 months. Now regular tender that has been.
We're concerned that this supply should not be disrupted.
Yes, my lord. That
It's
is
not disrupted.
Yes.
I will reply,
Because I don't-
12% less. Than the estimated.
Put in usual course.
In-
Or after 2 weeks.
Date may be
We'll take it
my
2
lord.
weeks.
On 21st, my
21st
lord.
of July.
एक दो दिन बात करते हैं।
July.
वही तो 23rd, 24th.
23rd, and
When was next?
then on 17 or 18.
17 we are closed. We are closed.
18 July, my lord.
It's
because-
closed. Vacations.
Oh, sorry, my lord. Then on my lord,
After 3 weeks, so you just
a
look at
fixed
it.
date may be given, my lord.
I agree that you did. Yes.
On 23rd.
23rd.
Well, interim order.
Interim order parcel is continued.
Apply.
Number 7.
May it was not.
Yes.
In this case, I made a prayer for bringing those IS that is not received yet, but already has been already published.
Huh?
So maybe take it after some time also.
Yeah, I'm on this. Plus 1 point. This next, after some time,
Yes, Lord.
then
Then next time also.
connected.
No, not connected.
Your lordship, we need some time to file affidavit, your lordship.
Heard Mr. So-and-so, R. Sharma,
Yes.
Land Council for the petitioner. On the prayer of Mr. No, MS G. R. Basalla, Mr. Francis. Granted for the 3 weeks time to file affidavit.
Some
Apply.
derivatives, lordship.
Hmm.
Some derivatives.
Yes, you just.
July.
22nd July.
Okay.
No affidavit. Seven to 17. You file your counter. Who is for 17 to 7? 7 to 17.
Your Lordship, I am for 7 to 17.
Yes.
Your Lordship, in this matter, there is monthly respondent, so we need further time to file.
Okay.
Lordship, this matter has been pending since 2023. It has been 2 years. They have been repeatedly taking time. They are not filing their reply, Your Lordship. So, Your Lordship, last opportunity may be given to them.
Mr. So-and-so,
M. Kambo.
Kambo. Miss so-and-so. Your
A. Rai.
Lordship, I'm body respondent number 6.
6. You have filed your affidavit.
Yes.
Only 17 to 17. Huh?
7 to 17.
7 to 7. So-and-so, you just record there. No? Just give it. MS so-and-so, Land Council appearing on behalf of respondent number 7 to 17 is granted for the 3 weeks time to file affidavit. 3 weeks.
Your Lordship, it may be made sure last opportunity they may be given.
That's the person. It's okay. We'll see.
Lordship,
What is the matter?
basically it's for re-investigation.
Huh?
Re-investigation.
Re-investigation.
Yes.
For what?
In police case number, Raga police case number 30.
It has been culminated into FR.
Pardon me?
Has it been culminated into FR?
Yes.
Anyway, you read the brief and come back. You read the next time you read the brief and come. Huh? Okay. Don't read here. All right. Sir, we're waiting for this.
I tried,
Hmm.
they are not open for discussion.
Hmm.
I made a call, but sorry.
No, I'm sorry. You have not made a call. I don't know.
Actually, concern I was here.
Sir,
Very good.
you knows
Yes.
me so well, sir. You are mine.
If my esteemed colleague is with me.
No, I have no objection, sir. So whatever sir's issues can be put, Milord. My issues are also there. Both the issues, because it's all equal, parallel, because there's nothing in difference, because if you log only language is different.
Only subject to, I just clarified my problem. I have no issues so far as issue number 3 of my London friend is concerned is perfectly all right, 100%. Other issues, I have a slight problem with the language. Lordship Messi, for example, issue number 1. That's why.
So we're not going with the language, sir. It's okay. We're framing the issue.
Yes.
But
All right.
kindly, there's something very important I'm pointing it out. Otherwise, we will be prejudiced. There is something. Let me explain why I'm concerned.
See,
Lordship, kindly, please, if my lord, you speak for a minute.
Mr. Rituraj is agreeing you
Whatever
all
issue.
your draft issues. Why you should
My lord,
quarrel?
please, feeling I understand, but my problem will be if his issues are taken.
You being an elder brother, you must take the lead.
Lordship, kindly, I'm saying something. Let me explain that.
Yes.
If the issue framed by my esteemed colleagues are taken as they are in the same language, that will cause a severe prejudice for one reason. Let me give an example. Issue number 1. Whether the election of the respondent returned candidate from 19 Yapin SP Assembly constituency is liable to be declared void under section 101B of the Representation of the People Act 1951. Perfectly okay. So far, so good. Thereafter, on account of commission of corrupt practice, including suppression of material information in Form 26, including failure to disclose assets, arm license, details of family members, and criminal
Yes. This will not say.
Yes, the problem. Yes, the problem.
Mr. Biswas will say.
The answer is yes.
On account of.
Issue can be answered right now. It is yes.
On account of commission of corrupt practices. Yeah.
So that is why we not.
That may be corrected. That's not.
That is why we not. That's why the question will be then in that case whether there was commission of corrupt practice, whether there was suppression of material information. So both the things are vital. But can't presume that there was commission of corrupt practice and suppression of material information.
See, when you say assembly is liable to be declared void under section, so what is the grounds for declaring the election void under section 1? That's enough. Whatever is there. So according to you, it should not be last 3-4 lines should not be there.
It may be here in a different form. That is why Lordship may kindly see my issue. There are total 6 issues. I'm not into the bifurcation. All 6 issues, Lordship may see one after another.
Yes.
Issue number 1. Whether written candidate respondents failed to disclose any material information in Form 26 affidavit, and as to whether such non-disclosure resulted in exertion of undue influence by the respondent on free exercise of electoral right of the voters under section 123(2) of the Representation of People Act 1951. I'm sure my esteemed colleague may not have any problem. Then 2, whether written candidate, respondent, or his agent, or other person acting with their consent committed an offence of booth capturing within the meaning of section 135.
You are reading your draft.
Yes, I'm reading draft.
Your
Yes,
draft.
yes.
His draft.
My draft.
Just wait.
Should I give another copy?
What is this?
It's okay. Do you have another copy? It seems it got misplaced.
Yes. I have page number. Resolution is not there. This is going to be out. This one. 1, 2, 3.
Issue one, whether written candidate respondent failed to disclose any material information in Form 26 affidavit, and as to whether such non-disclosure resulted in exertion of undue influence by the respondent on free exercise of electoral right of the voters under section 143(2) of the Representation of People Act 1951. I'm sure my state should not have a problem. It is clearly worded. Then number two, whether written candidate, respondent or his agent or other person acting with their consent committed an offence of book capturing within the meaning of section 135 capital A at 30 feet, 29 Rambagh, 16 Bagba, and 20 Sangram polling stations, and as such committed corrupt acts under section 123A of the RP Act 1951. Then number three, it should be read as three, though I have bifurcated it, but Lordship may take one after another. Then number three, whether votes of dead voters were cast in 30 feet, 24 Rova, and 16 Pampa polling stations, and whether casting of such votes materially affected, because that is the language, materially affected the outcome of the election in 19 Yapen ST Assembly constituency under section 101D3 of the Representation of People Act 1951. To the next, the votes of bogus voters, proxy, non-existent, we are cast in 24 Rova. First one is dead, second one is bogus, proxy, and non-existent. We are cast in 24 Rova, 30 feet, and 16 Pampa polling stations, and whether improper reception of such votes materially affected the outcome of election of the respondent from 19 Yapin ST Assembly constituency under section 101D3 of the Representation of People Act 1951. Then next, whether votes of double voters, all the three I have taken one after another, bifurcating them. Whether votes of double voters were cast in 30 feet, 16 Pagba, and 24 Rova polling stations, and whether improper reception of such vote, because if they were cast, they will be improperly received. That is understood. And whether improper reception of such votes materially affected the outcome of election of the respondent from 19 Yapin ST Assembly constituency under section 101D3 of the RP Act 1951. The next, whether postal votes, so that issue has also been raised. Whether postal votes were improperly received and such improper reception materially affected the outcome of the election within the meaning of section 101D3 of the RP Act 1951. So, my lord, in addition, apart from these issues, in addition, so far as my learned friends issues are concerned, issue number 3 is perfectly worded. But I think it has already been covered by issue number 3. Now, my lord, there is another issue which is additional he has raised, which I have not covered. Lordship may consider that. That is, the problem is issue number 6. Lordship may kindly see the language. Postal ballot I have covered, but then various irregularities in the conduct of election, including the custody of postal ballots by unauthorized authorities. So, the language ballot postal ballot issue I have already covered. So this problem, the manner in which it, no, not, there is one new issue which he has raised, I have not raised. Issue number 4, Lordship may look into that, I have no difficulty. Only the language will be important. Issue number 4, whether denial of assistance of the polling agents to the petitioner amounts to violation of the provisions of the Act and the rules made thereunder, and therefore the election of the respondent deserves to be set aside under section 101D. Now, the only problem is, it is starting, denial of assistance is presumed. So, this should not be there. Whether there was denial of assistance of the polling agent, and it amounted to violation of such and such. So, that language.
That may be correct.
That, yes.
That may be correct.
That issue I have not covered. It is true, my lord, in the pleading, this is there. Regarding polling agent, pleading is there. I admit. I did not include that issue.
And lastly, my lord, my 7.
There could be a problem that I'll show. Because, my lord, since recrimination petition is there, in view of the Supreme Court judgment and also of the coordinate bench, it's only, my lord, if the election petition, my lord, if my election is declared void, then in that eventuality, had there been no recrimination petition, this issue could have been decided.
Yes, when there's a recrimination petition, it may not be. Yes,
Recrimination petition.
yes,
So it is subject to the outcome of the recrimination petition.
yes.
It can't be answered.
My lord, I have one side, sir. Because, my lord, recrimination petition, my lord, section 97 and the judgments, it says, my lord, once the prayer under 100 is considered, and thereafter the consequential prayer of declaration of the writ petitioner as a returned candidate under section 101 will be considered. But it doesn't say, my lord, the issues will not be framed. Because only thing that is deferred is
when it is not
agreed.
when
In that case, my lord, issue may be there, but then my lord will not answer the issue.
yes, only when lordship will decide these issues, and if it
No,
is in
when-
my favor, then only that issue will be
Very
considered.
good, very good.
I have no problem.
And again, agreed.
I have no problem. Lord, only thing is, my learned friend has given this issue number 2, that is at page 2. There are 4 polling stations.
4 or 3?
There are 4. Actually,
I have
that
seen
has
how
been
many?
missed out.
How
Because
many are? I have seen how many?
if you see your lordship, page 2, 1, 2, 3,
Lordship may put
29, 29 Kambang is missing.
Then the
Achha,
maybe
according
put
to
it.
you, these,
Continue comment is there.
Next page.
this 6 issues,
All right.
Yes.
draft
Yes.
issues filed by the
Dead voters.
Mr. Tiwari
Yes.
can be framed.
It is almost identical. You know,
Ah.
there's this can be
Based only, including the issue number 7.
my issue number 7, because my issue 1 to 6 and my learned friend's issues are almost identical. It is almost only the language changes there, and one polling station has been left out
That is in this.
in dead voters. The polling.
29 compound may be included.
And my 4 also, my lord.
And
That may be.
yes, the 4 one, bogus voters.
Yes.
So dead voters and bogus voters were not in these 2 issues. It seems I left out 29 Kambang.
Yes, yes,
Is
yes.
there in the list?
Yes, yes. There are 4.
29 Kambang may be included. Maybe it is my mistake.
So yours is total 6.
Yes.
6. And from him.
Issue number 7 of his.
4 and 7.
4 and 7.
4 and
Also, not has to be language has to be.
Oh, that is okay, my lord. That I agreed. Whether there is a denial of assistance, that's my learned friend.
Yes, yes.
That's okay.
Yes, yes.
In number 4, whether denial of assistance, instead of that,
Yes,
whether there is a
yes.
denial of,
Yes.
that also will be decided by lordship.
So we'll say that whether there is a
Denial
of
assistance of the polling agents to the petitioners,
And as to whether the same resulted in violation.
whether the same amounts to violation.
Affecting the validity of the election, because violation may not, every violation may not affect the validity of the election. Violation
Yes, to the-
affecting the validity of the election,
as to whether then
as to whether the same
Amounts to
violation
of the provisions of the act. and the-
amounts to affecting or violation.
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 Violation
Achha.
of
As
the
to whether-
provisions in the act.
And the rules made there and therefore the election. So 1, 2, 3, 4, 5, 6, and then 4 and 7.
Do not amounting to violation of the provisions of the act and the rules. And as to whether the such violation would invalidate the election, because all kinds of violation may not.
That
It
is,
all depends upon the categories.
the language is there. And in
Would this 7 be required?
yes, Miller, because his recrimination is there on record, Miller. Now, the judgment say that on recrimination will be decided once
Yes.
section 100 decision is taken, Miller.
Yes.
But it doesn't say, Miller, the issues will not be framed. Only thing is that issues will be framed. As a preliminary issue, my contentions will be decided by lordship, and it is in my favor only. Then he'll get a chance to lead evidence on this issue.
I have understood what my learned friend is trying to say. Let the issue be there, After, if he succeeds in the election petition and my election is declared void, then my lord will take up the recrimination.
Huh.
Once the recrimination is decided against me, my recrimination is decided against me, my lord will answer the issue number 7
Yes.
in his view. That issue
So
would
issue,
remain in abeyance.
it's a joint trial, it's a common trial,
Composite.
trial. Only thing is that it's like a preliminary issue. Like the limitation, jurisdiction is a preliminary issue like that. Our issues will be decided first and then the recrimination. That can be done.
Because in recrimination also will not actually issue can be framed. So I left it for recrimination.
But it can be done here also.
Either way, I have no issue. I have no problem. These
Mr.
are small things.
In my learned friends 1, 2, and 3 in page number 2, that one polling station has been missed out.
Yes, yes.
29 Kambang, that my lord.
We'll do that. 29 Kambang.
Kambang, that is included.
Oh, it was.
Not in 1. In 2, Kambang is there.
No, not
3 and 4.
I mean the next page.
3 and 4. 3 and 4.
But your serial number is 1 and 2. So that's,
Anyway, just since I forgetted it just to show. In serially, it will be 3 and 4. Kambang is to be included. 3 and 4. Which is 1 and 2. Under the heading, readings, but no healthcare. 3 and 4. Kambang is to be included.
30 pin 24 row 16 Pagma.
इसमें भी आएगा.
5 also.
What is the other Kambang?
Kambang.
Number?
29.
29. 29 Kambang will be included in issue number 3, 4 and 5.
1
Right?
also. 3, 4 and 5.
3, 4 and 5. Serially.
29 Kambang.
Will be included in 3, 4 and 5. Serially. Otherwise, if bifurcation is there, then in 1, 2.
You take this from this wherever is
I'll
29 Kambang is not there. You take it from this. Issue by the 3, Yeah. There are 3 polling stations, 16 Pagba, 29 Kambang, 30 Pil and 24 Robo. 4 polling stations. Third Mr. Rituraj Biswas and Mr. Kapil, DJ Kapil, London Council for the election procedure. And also our Mr. PK Theory, London Council for the then senior counsel assisted by Mr. Aril Tungon, assisted by then counsel for the response.
The number of focus voters is inquiry conducted by petition.
After hearing the
Connection
then counsel for the effects.
connection number
And on
17.
polling issues are polling issues are hereby framed. 1, 2, 3, 4, 5, 6, 7. I'll show you. That's all.
Yes,
And then?
Now we have to file our list of witnesses, my lord.
Yes.
So that.
In 15 days from the date of settlement of issues, as per the law.
Yes.
So within 15 days, my lord, we will share the list of witnesses. And then your lordship will fix a date for leading evidence, my lord. We have to file the affidavit of evidence and all that.
Yes.
First list of witnesses.
Yes.
My lord may recall, I am refreshing the memory. There was a long time ago, the lordship argued this case. There is a reported judgment of Justice P.K. Bushairi. The senior of my other junior colleague, S.S. Day was on the other side. Your lordship was on the other side. And argument of Mr. Day was the requirement of this 15 days is not a mandatory requirement. It is absolutely directory. And the argument of your lordship was it is mandatory.
Okay.
The Justice P.K. Bushairi came to the conclusion it is mandatory.
Okay.
15 days time limit is to be maintained.
So we'll fix after 15 days.
Yes.
For
15th day
For filing of the
filing
list
of
list of
list
witnesses.
of witnesses.
the day from today.
Yeah. Then we'll say list the petition for list the matter for list after what we'll say 15 days.
Yes.
Or fixing the date.
Last says 15
You
days.
just skip it.
From the date of settlement of issues.
Today is 20th. So 15 days should be.
Then fifth
Fifth is a
of-
Saturday.
Let is fourth,
Fourth.
Friday. It's
It's
only for
Friday.
filing of list of
List of
witnesses.
If some
yes.
difficulty comes, we have to take leave of the court.
List.
Apprising the honorable court of the difficulty.
Yes. I'm grateful and I'm enlightened.
Whether my lord remembers that, it's a reported judgment
Okay.
of Justice P.K. Bushari.
List on 04/06/2025 for filing of list of witnesses. Hopefully, things should proceed smoothly.
Possibly this will be the first
Yes.
case that will be concluded.
The list of. Oh, numbering Garvard House.
No, I'll see it there.
Huh?
I'll see to that.
Yes.
Yes.
So it was wrongly mentioned. Numbers were wrongly mentioned. After 1 and 2 again, 8, 1 and 2 again, 8, so I've corrected. Sir is corrected. मैंने दे दिया सर आपका corrected वाला.
Grateful. 7. Yes. What is this?
So, today's fixed. The respondent has not filed any affidavit in this case till now. Today I filed 3 IA. The first one is 161. It is for stay of one WTMS. Why this WTMS? It is at page 45. Regarding promotion to the rank of.
One is for what? There are 3.
161 is for
Three
stay.
IAs for what?
Yes, first one is for 161. That is for stay of the WTMSs. The second one, 162. That is for amendment of the repetition. I want to incorporate one more prayer and one paragraph. And the third one is for implement of the parties, because I am challenging this WTMSs where some other persons shall get affected.
No, in that case, we'll just allow you to amend and the amendment is for what?
I want to that when I filed the repetition, that WTMS was not issued.
See, first you amend it, then we'll think about the stay.
But Lordship, that
There's
stay
no question of stay.
Lordship, I kindly see my petition. This
See, you are seeking an amendment for you. First, we'll allow you to amend the petition. Then we'll.
But in that case, Lordship, we shall be aggrieved. The department may proceed with the DPC process.
Obviously.
So, Lordship, Lordship may amend my prayer.
See,
allow me to amend. I shall file the
now they are contemplating to conduct the DPC, hold the DPC in terms of the rules.
In terms of the rules, but that rules is not applicable.
2025.
Yes.
Whether it is applicable or not, whether you are entitled, we'll determine first. Today, how can we if had it been a case that they are going to conduct the DPC without following the rules, then matter would have been different.
My case is
What is your case is that when the rule was not amended,
yes,
new rule came into effect, there was the post poll vacuum, and there was no DPC, right?
Yes.
Therefore, when
they initiated the process of holding DPC,
yes,
vigilance, etc., all are taken, but they did not hold DPC.
Yes.
Thereafter, this new rule come. My case is I should be given the promotion on the basis of the earlier rule, because at that time everything was taken. Vigilance was also done. So, let me see the present position.
No, I have seen it. What's there? Now, problem is you want to amend your writ petition.
Yes, Lordship.
Once you amend it,
Lordship,
we'll allow the
I have-
IA for amendment.
I have one alternative prayer also. Lordship, I filed one representation. The department on 4/2/2025. That is not disposed of yet. So, if your Lordship allow direct them to dispose this writ petition, representation, And till the disposal of this representation.
No, these
State,
tricks have been done away. We're not, no longer where we cannot be.
That's true, but Lordship, thing is that if this representation is dissolved, then okay, Lordship.
These tactics of the lawyers had been not been accepted.
Lordship, give me some moment. So kindly see this 161, page number 23. It is a seniority list.
Sir, you tell us. You have filed the IA, which IA you want to? The entry stay of the proceedings of DPC, we are not going. We'll pass orders. If definitely will consider your submission. Are you pressing for amendment of the writ petition? First
Yes,
decided. Then we'll dispose of that. You amend that. we'll
Lordship
do
may
it.
allow the amendment, then matter may be fixed in the next week. This matter may be fixed in the next week. By that time, I shall file the amended writ petition. And then I shall press the stay prayer in the next week itself.
So, whether at the time of moving this writ petition, whether your prayer was, whether you have.
No, at the time of moving this petition, then WT message was not there. At the time of moving this writ petition, WT message was not there.
Your Lordship.
On June 2000.
See, the pendency of writ petition shall not be a bar for the complaint respondent to constitute deficiency of filling up the vacant post of APPC entry grade. Petitioner shall produce a copy of this order to. What is this?
This is
an order
this was
already.
given in our favor, Lordship.
Huh?
This was given in our favor because our first prayer was there to hold DBC as per that rule.
So
that was accepted. Then, Lordship, to hold DBC to consider the internal items.
Yes,
Lordship, I have managed in my IA, Lordship.
Your Lordship,
It is
the
available.
petitioner has filed
Just
earlier
wait,
repetition
just
also.
wait. What is this?
The next A in my IA, Lordship.
Sir, look at the order. Pendency. Second last para.
Yes, Lordship. This one. Yes, Lordship.
Read it, please.
I've gone, Lordship.
Sir, please read it.
The pendency of this representation shall not be a bar for the competent authorities to consider DPC for filling up the vacant post. Lordship, I come to the first para, Lordship. Then only it will be clear. The petitioner's project that 19.
No, wrongly, rightly, whatever order is
Lordship,
there.
Lordship,
So how
kindly-
can
kindly
we
see the
pass
first
a
para.
contrary?
Lordship,
You want us to modify that?
Lordship, first go to the first para, then the meaning will be coming. The petitioner's project that 19 posts of APS entry of the rank Deputy Superintendent of Police Assistant Commander which are required to be filled up by promotion has been fallen vacant since the year 2022. And the said posts are required to be filled up by promotion from the eligible senior most inspectors of the police organization of the state, such as APPBN, IRBN, etc. However, currently the DBC has not been conducted. The present representation has been filed under Article 26 of the Constitution of India. Now the pendency of representations cannot be a bar, Lordship. Next bar. So, Lordship.
So what is your case
During
now?
the filing of this petition, Lordship, the new WT message was not coming. That new rule was not available.
Therefore, you first amend your writ petition.
Okay, Lordship. That is what I am saying. I shall amend the Lordship may pass the order today. I shall amend it by the next week. And matter may be taken up in the next week.
Heard Mr. So-and-so, learned counsel for the petition. Answer, learned counsel for the petition. This is which one? Amendment for amendment?
For amendment, Lordship. 162.
And Mr. MSG R. Basar, learned state counsel for the opposite party respondents. This is an application for praying for amendment of the writ petition being WPC number 172 of 2025. Application for amount writ petition to insert a paragraph for will not say holistic. Having considered the submissions and the grants of seeking amendment, and as you don't have any objection.
Lordship,
You cannot.
there is one more read petition where WT message has been challenged by the present read
They want
petition.
to amend this. Do you have any objection?
Lordship, no, amendment is not.
And prayer not being objected would by learned state council, they consider that I deem it appropriate to allow this application accordingly. The applicants, public petitioners is permitted to amend the writ petition being so and so. Which para?
Lordship, I have given in schedule, Lordship.
What it is?
After the prayer. After prayer 31, it should be 31A. And the prayer B.
You just read it. In the following paragraphs, huh? And in the following paragraphs, huh? At paragraph 31, huh? Is para 30 by adding the para 31A, huh? As well as in the prayer portion, adding prayer number B, huh? Page 11 and 12. Assistance allowed the petitioner to file an amended writ petition. Huh?
Lordship, matter we fixed on 25 of July.
You have prayed for that stay in that.
Yes.
So we'll close this, or you withdraw this other two.
When that will be listed? That
Why unnecessary? They should
no,
be.
that interim stay I have not made. There I have since I have filed separate petition. Therefore, I have not made the application for stay of that. But because in the stay petition I have made and some documents also. That is to be considered.
No, this your amendment will not be this thing will not include setting aside in question. You have not made any interim prayer.
No.
In the writ petition.
In the written there is an interim prayer, but not in this connection. So therefore, separate I have filed.
And then
also rest to may be taken up in the next after on 25th. That on 25th.
The IA is disposed of writ petition be listed on 25th. Yes. Whatever the other IA.
One is for implement of the persons who will be affected if our prayer is allowed. That I have made that 163 by number.
This also will allow.
Not sure.
Will allow and
Yes,
both heard so and so. This is an application for praying for it. Implement of how many persons?
There will be 68.
Huh?
From 9 to 60, it will be 59.
59 persons.
59, 60 lots, not 59.
60?
Yes.
Are you sure?
Yes, it is 60. 60.
60?
Yes.
60 persons.
What
Yes.
will it
Is it 60? 9 to
because,
60.
because some person who are near to me, I am not making them party lots. They are otherwise also get
Forget about, I'm asking how many persons?
60.
60 persons. You calculate, huh? 9 to 68, 60%. Were you a science student? You are also us. 59, say.
It's 59. No?
Yes.
59.
No. 9 to be included in that.
9 to 68.
68 minus 8, therefore it is 60.
It's 59.
68 minus 8 because it starts from serial number 9.
It's 59. Lordship.
59?
Yes.
Or 60?
59.
Yes, commerce, become.
9 will be perfect.
9 to 68.
Yes.
Yeah. We'll go by the become. Why? Truly you are a arts student. Huh? Having considered the application, having considered the submissions and the prayer for improvement, is agreed to by, has not been objected to by the State Council for seeking improvement. I find the persons proposed to be included are the necessary parties. Appears to be necessary parties as the challenge to the proposed DPC. The persons are to be considered would be affected in the event any order is passed in this proceedings, in the connected writ petition list. Thus, I deem it appropriate to allow this application list accordingly. So and so persons, huh? You have given the list.
Yes, Lordship.
The following persons are allowed to be implemented in the connected writ petition. List allowed, disposed of. Allowed and disposed of.
Next year, Lordship, 25-16. 25-16 in the next week, Lordship. Probably.
Yes.
Yes, my lord. My lord, this is relating to the petrol pump case. Petrol pump, Bharat Petroleum for retail outlet.
Yes. What is to be done today?
My lord, in this case, the respondent number 5, the territorial manager of Bharat Petroleum Corporation Limited, Guwahati, made an advertisement.
No. What is it? Why this is listed for today?
So this is for this admission hearing.
No. It is listed for orders.
Orders. Lordship, they have not, respondent has not filed affidavit.
Yes. How many days?
Madam, I'm for the respondent number 1, madam.
The
other respondents are the main respondents who
is the main respondent?
Main respondent number 4, 5. That is territorial manager and project
Service
manager.
is completed.
We have,
Is the service complete?
yes, they have received and already filed the receipt copy here before this court. Already received.
They
Last
fi-
order,
no,
last
no.
order was to just the respondent 4, 5, 6 has to file affidavit.
Okay. Further 3 weeks time will grant. All right. Heard Mr. Arnabam, Land Counsel for the petitioner, and Mr. You are not filing affidavit.
No, my lord, affidavit is
Uh,
Not, sir,
I'm
they're
Kata-
not necessary, unanimous, they're not necessary in this case.
If the DSG non appears for the other response, for the 3 weeks times you granted to file them. For the 3 week time is granted for filing affidavit.
Lordship, 2 weeks, since
2 weeks.
2 weeks is an interim to continue.
Interim past earlier shall continue.
developed.
Lordship.
What is this?
This is a land acquisition proceedings, my lord. I am for the private respondent.
So,
in my favor, the award was passed. There were 5 people. For 4, payment has been released. The matter went up to the DB, and in that DB, the award and the notification has been upheld. Now, everything was over. Now, after that, my lord, my learned friend has filed on behalf of some of the claimed to be from the same village, saying that they were kept in dark and this was all behind their back. So my contention is, my lord, there are 4 rounds of litigation, 2 judgments by the single judge, 2 judgments by the DB, 1 judgment by in the Supreme Court. And after and if at all they have to challenge the DB judgment. Now, my lord, last order, lordship may kindly see. That order, the state government was requested to produce the records.
to produce the record.
Records, yes.
Well, we have received records from the litigation.
Original records.
Yes, original.
Well, fix it for hearing. Today
Yes,
list for that.
But here in the original reports, the preliminary notification, the publication is not there. There is a publication of after the preliminary publication. But as I've seen,
It's an incomplete record.
Yes.
You get Wolf.
Then
Art Mr. So and so, then council and so and so. Or which was correspondent number?
7.
7. As directed by this court on so and so. Who's that? No, Mr. N. Learned Additional Advocate General submits that. Although he has received the records as directed by this court on 22/05/2025,
from the technical.
The same are incomplete. Same is incomplete. Dear press for
Instead of
placing the complete
incomplete,
record.
I may be allowed to ask the record from the land.
Additional records.
Additional record.
No, although the record has been received from the Deputy Commissioner, he may be allowed to obtain the records, additional records from the Land Management Department. List. Praise the Lord, let this matter be listed. Up to 3 weeks.
On 28 July.
So 3 weeks, 4 weeks.
Effects.
On the next date, then the additional advocate general shall produce the complete records in original.
Lordship is fixing a date now.
It's up to you.
28 July.
28 July.
My lord.
Yeah.
Deeply august.
Record is.
Grateful.
My lord.
My pleasure.
Yes.
My lord, in this tender matter, my lord, the petitioner was bid was rejected on clause. My lord, I'll just nutshell, my lord. Clause saying that he has not sufficient.
Why this is listed for orders today?
My lord,
Well,
we have-
yeah,
last
Petitioner
time-
already withdraw the EMD. Now.
they have given, my lord. It's not that.
You should not accept it.
My lord, this was in orders because my lord, we had to file.
We
application.
cannot say that after this thing, we cannot say that to resubmit the EMD. Why you have accepted it? You should not have accepted it. You should have asked it to keep it since the matter is pending.
Well, yes, this matter has been fixed because we were asked
Have
to
you
take.
filed the affidavit?
Yes, ma'am. Malad,
And
just
what about this respondent?
yes,
Does
for that,
they-
Malad, we have taken steps twice, Malad, on Dusty.
Dusty, have
So,
you filed the
yeah, we have filed
affidavit?
We have filed affidavit.
It has been deemed served?
Yes, ma'am.
Any order of this court?
No orders.
So maybe because of that.
Yes, ma'am.
Okay, third, Mr. Peter, learned counsel for the petition. And Mr. The G. Tarak, counsel, still the counsel for RWD, huh?
1 to 5.
An affidavit has been filed by the petitioner reflecting the proof of with regards to the proof of service of notice by Dusty Mott, Mr. on perusal of the where it is Where is the affidavit?
my lord, my lord, we have annexed. Page 472, 472 and 473.
This is respondent number?
Yes, Tamchi Kusuk, my lord,
Respondent number.
respondent number 6. And
Yeah.
next is the respondent number 7.
Okay. So that reflects that the respondent number 6 and 7
Yes.
have really received the notice. List of accordingly. The services in respect of respondent number 6 and 7 are treated, served, huh?
Earlier also, my lord, it was deemed served, my lord. Then again, we were
Not
direct.
deemed served.
No, earlier, my lord.
Treated served. Huh?
Yes.
No, will not treated. Service in respect of respondent number 6 and 7 is duly served and complete.
Yes.
Huh?
Yes. My lord,
List.
Don't
the
let, my
matter
lord,
after,
no use in keeping this matter alive, my lord.
no, problem is that that's why I'm saying.
Yes.
Or else you withdraw it.
No, my lord,
When list the matter for admission.
yes, 26, my lord. Yes.
26.
Obliged.
Number 16.
Yes.
Yes, the Union of India has to file their affidavit.
It has been filed, I think. Affidavit is on behalf of respondent 7. Who is respondent number 7?
7 is the one, ADC.
They file, you have filed. Whatever the
My lord, Union of India, my lord, will take time to file affidavit 4 weeks.
Mr. B. Pitcher, Learned Counsel for the petitioner. It is submitted by MS Arbasad, Learned State Council, that the state has the affidavit on behalf of the state respondent has already been filed. Mr. Next, Mr. No, on the prayer of Mr. M. Kathal, Learned DSGI is granted for the 3 weeks time to file affidavit.
Leave them.
What is this?
Well, this is condonation of my lord, delay in filing connected writ petition file. So my lord, if the exit date of the impeachment has been in order, my lord, delay is only 39 days, my lord. So my lord, delay may be condemned, my lord, on
Filing
merit.
of what?
Filing of my lord, what if an arbitral award was passed by sole arbitrator, then against that award, my lord, they file application before the my lord, the district and session judge Bomdila, my lord, civil judge Bomdila, my lord. And district and session judge my lord Bomdila passed an order. My lord, exactly after conclusion of the hearing, the order was not exactly passed on the same date when it was fixed for passing order, my lord. Then subsequently we came to know from the registry, then order was passed. Admittedly, on such date, it was not passed. So,
any objection?
My lord, senior conducting counsel is.
My lord, we have filed our objection, written objection, my lord. If your lordship kindly sees the application under section 5, in paragraph 5, somewhere it is written as 117 days delay, and paragraph 8, 47 days delay, in paragraph 9, 82 days delay, and in paragraph 11, there is 156 days delay, then 39 days of delay, and in the prayer portion of the lordship will kindly see in the prayer portion condemnation of delay of 39 days or 156 days in filing the
justification is
or 156 days in delay.
My lord,
So I have
justification
seen such
is
type of petition for the first time.
my lord,
where
if
there
We'll
lordship
not go
is
into
either
it. You work it out and come back. We'll take
No,
it
my
up,
lord,
take it up on Monday.
it is 39 days.
Definitely will. He is is, or you file an fresh copy by exactly calculating from till the filing of this.
My lord. My lord, why this has been explained is because, my lord, on the date when it was fixed,
No, he has filed an objection.
My lord.
He is not able to understand. You have filed a fresh study. What is your objection?
My lord, this is first and foremost that.
Forget
this is
about
my
what is there, but you tell us how many days there's how many days of delay
There is more than 156 days delay, my lord.
according
And
to
in
you.
yes, and the
Ah.
lordship, my lord, in the Supreme Court in a recent judgment of 2020 has confirmed that such a delay, more than delay of 120 days, should not be condoned in preferring an appeal under Section 37. And in another
No,
judgment,
see, Mr. Dar, he said it's only 39 days.
39 days only, madam.
he has not annexed the copy of the certified copy of the order passed by the learned district judge Bomdila, from which we can gather that there is only 39 days of delay.
Sir,
according to
maybe
him.
we'll take it up the next week.
Madam.
Monday, Tuesday, Wednesday, whenever. But make yourself clear what
It is clear, madam. 39 days.
Huh?
39 days.
Huh?
39 days, madam.
You make
Delay is
yourself
admittedly
clear.
39 days. It's because from the date of the receipt of
And
the
then
order.
you produce the certificate copy also.
Madam, it is
From the day of obtaining you are, calculating, the computation is from the day of obtaining the certificate copy.
Yes. My lord.
He said it's not there also.
My lord, what happened?
There
After
is not
conclusion
on
of the
record.
hearing, my lord, my lord, categorically made a statement in my lord, the applications that order was reserved to be passed on 20th July 2024, my lord. On 20th July, no order was passed. And my lord, if we go, my lord, and on subsequent date, it was also not passed. On subsequent date, it was not passed. But when the district and session judge was transferred from Bomdila to UPR, then we came to know that the order has been passed. Then we applied. On 14 November 2024 only, the copy of the order, the certified copy of the order was furnished to us.
24?
14. It is written 14 November 2024, madam. 20 July, that is the pronouncement of the order and judgment after conclusion of the hearing, on which date no order was passed. And thereafter, no order was passed. Again, no order was passed. But order was passed very
Matter was taken up. When the matter was listed, it was listed before the court.
No, thereafter, no date has been fixed.
No, you said that first when it was listed, no order, no judgment was pronounced, no
Yes,
order was passed.
Yes, ma'am.
Then second day it was listed.
Not listed, madam. Even no order was passed.
No, when how can you, why you are saying that the first day no order, second day no order?
This is there is no
When
fixed.
it was not listed, what's the question of first, second, third day?
Madam,
It has to be listed, then only you can say that it was
It is not known, my lord, when the matter was fixed, when order was passed. Therefore, my lord, we have categorically made. My lord, if we go the detailed inquiry of the matter, my lord, it will go against the, my lord, the order passed by the presiding officer, my lord. So therefore, my lord,
No. Whether it goes not, if it is not properly done, it is not be proper.
My lord,
it has to be the as per the law.
My lord. My lord, paragraph 5, my lord, we have explained everything. My lord. Paragraph 5, my lord. Just for my lord, proper understanding, may I take your lordships to paragraph 4, my lord, before the marriage, my lord, paragraph 4, my lord. That the applicant begs to state that on 20 July 2024, though the case was fixed for pronouncement of the judgment, but no judgment was pronounced on 20th July 2024, madam, by the learned court below, and which date the representative of the applicant's department was remained present, but the judgment and order was not pronounced by the learned court below. Accordingly, the representatives of the applicants intimated to the DSCI to intimate the present positions of the case by letter number 22 July 2024. By that, no order was passed. Next paragraph, my lord. The applicant begs to state that when the representative of the applicants came to know about the transfer of the presiding officer who heard the matter, confirmed from the DSJ about the case and its judgment, on which the learned DSJ asked the representative to confirm from the judgments of the about the judgments of the aforesaid case from the learned court below. Accordingly, the representative of the applicants filed applications for furnishings of the certified copy, certified to be true copy of the order passed by the learned court below. The office of the learned court below on 11/11/2024 furnished the original copy of the impugned judgment and order dated 20th July 2024 passed by the learned court below, which was immediately called back by the official of the learned court below, stating that they have wrongly furnished the original copy of a copy on 11/11/2024. And accordingly, the representative of the applicants returned back the original copy of the impugned judgment and order dated 20th July 2024 to the office of the learned court below on 14/11/2024, on which the office of the learned court below duly furnished the certified to be true copy of the impugned judgment and order dated 20th July 2024 only on 14/11/2024, by which there was already delay of 117 days if delay is counted from the date of the impugned judgment and order dated 20 July 2024, but the judgment and order was not pronounced on, and it was not pronounced, on affidavit we are swearing, and the same was duly intimated to the head authorities, headquarters solely, Tenga, by the applicant number 2, and same was also intimated to the DSGI for so and so. It is not only the single correspondence where this is done. Time and again, we are intimating to the authorities. Now, applicant begs to state that impugned judgment and order that was obtained by the representative of the applicant, and the same was duly intimated to the learned DSJ for furnishing legal opinions on which the learned DSJ gave the legal opinions for filing appeal against the impugned judgment and order dated, which was already forwarded to the headquarters Tenga by the respondent number 2, and accordingly the applicant 2 requested the DSJ to file an appeal so and so by letter number 25th December 2024. Now, applicant begs to state that the respondent requested headquarters to prepare. I will not read all these things. The delay is para 9.
No, 11 you just say it's okay. You said there is a delay 150 days if it is counted from the date of judgment. Huh? If it is from the date of 14/11, date of the certified copy, it's 39 days. And then said there is a delay of 117 if the days of delay from the date of impugned judgment order 20 till the filing of connected admin. There is a delay. This is the problem. Why no one not able to understand?
Delay if it is counted.
Why 117?
117 minus
156.
117 is total days of delay.
From the date of judgment?
Yes.
Then what is 117?
117 it is
till the date of obtaining certificate, there is a delay 117. Oh.
So two ways of calculation, What we wanted to demonstrate before your lordship is, even if there is a delay,
170 days delay is from the date of
impugned order,
impugned order.
Yes, madam.
Then 156?
156 is, sorry, 115 is from the date of the certified copy, minus
117.
117,
117.
Yes, 117. If the days of delay from the date of impugned judgment, 20th, and
then what about 156?
156 is the delay. There is a delay of 155,
56.
156. I'm sorry. If it is counted from the date of obtaining of
certified copy.
Certified copy.
Then 39 is
39 is minus, my lord, 90 days, my lord.
No, no, that cannot be.
My lord, may I explain, my lord? From 15 November, my lord, when the certified copy was obtained, it was obtained on 14 November, my lord. That for 15 November to 23rd March, total number of days is 129, my lord. And minus, my lord, 90 days, then it comes 39 days, my lord.
The 13 days cannot be after the delay. You cannot minus this 39.
My lord,
30
it is
days.
just only showing the pragmatic, my lord, delay, my lord. The main delay is, my lord, if paragraph 13, my lord, then paragraph 12 and 13, my lord. Paragraph 12 and 13, my lord. This is the by days of delays has been counted in paragraph
You are
11.
counting, you are computing it from the date of certified copy.
My lord.
Huh?
It is 39 days, man.
So,
My lord, correct explanation
no, that's
is,
why you using the 156, 117?
my lord, 117 by that, my lord, one already 17 days was delay. And by that, after that, my lord, there was, my lord, each delay has been explained.
Matlab, from
Now, my lord, correct calculation.
from the date of judgment to till the certified copy,
My lord.
it's 117.
No, my lord, it is, my lord, days of delay, my lord.
That's
Not
what
total
I'm
days of delay, my lord. By when the, my lord, it is known to the, my lord. Correct explanation is, my lord, paragraph 12 and 13, my lord. Just for a moment, my lord, may I explain your lordship?
But the organization which no, I've understood. You are saying that is that if the delay of 39 days or delay, or why you are saying or the delay 150 days filing correct, why you have to sure how many days of delay?
My lord, delay, my lord, each day has been delay has been try to, my lord, explain the each days of delay, my lord. My lord, the correct total delay is paragraph 12 and 13, my lord.
No, why are saying Samir that if the delay of 39 days of or the delay of 150 days in filing connected, which one you are?
My lord, 39 days, my lord, from the date of order copy of the certified copy, my lord.
No, I just wanted to know why 115 days. I
15
understand 156.
My lord, if we counted from the impugned date of judgment is 20th July 2024, my lord, then it comes, my lord, 100, my lord, total number of days is 246, which minus, my lord, 90 days, then it comes 156 days, my lord, from the impugned date judgment.
Well, next week.
My lord.
When?
Any date, my lord, subject to convenience.
Yes.
Next week.
What it comes.
Yes, Mr. Dhar.
My
What do
lord.
you want?
My lord, next week, my lord. Or after vacation, winter
As
vacation,
agreed to by
summer
well,
vacation.
No, my lord, let us have it on 25th. 25th. I'll
25th?
I'll file additional affidavit.
Again on 25/06/2025. Additional affidavit, bring it clearly.
My lord.
Don't, bring all this thing. And serve a
Yes, ma'am.
It's a statutory appeal. You think about it.
It's true, my lord, that but there is something.